This is the brief on the foundations of Filipino criminal law. We're breaking down Articles 1 through 10 of the Revised Penal Code, the absolute bedrock of how crimes are defined and punished in the Philippines. So have you ever wondered if you can be considered a criminal entirely by accident? Let's get into the rules of the road. First, the law's reach. The system relies on the classical theory, emphasizing human free will. It's bound by territoriality, applying within Philippine territory and waters, including foreign merchant vessels, unless it's just internal ship management. It also uses prospectivity. Think of this like a strict no-takebacks board game rule. You can't be punished today for something that wasn't a crime yesterday unless a new law actually favors you. Now that we know who and where the law binds, how is a crime actually formed? Second, let's break down the mechanics. Dolo versus culpa. Dolo means intent, requiring freedom, intelligence, and deliberate action. But culpa means fault, stemming from negligence or a lack of skill. And yes, under culpa, you can absolutely be held liable without any evil intent. So once the intent or fault is there, how far along did the act get? Finally, we have the 3 stages of execution: attempted, frustrated, and consummated. It's kind of like baking a cake. Getting stopped while mixing the batter, that's attempted. Baking it perfectly but dropping it on the floor before serving, that's frustrated. You performed every act but miraculously produced no result. Successfully serving the cake is consummated. Ultimately, the architecture of Philippine justice relies not just on what happened, but exactly how, why, and where it went down.
Welcome to this video on the Revised Penal Code. In this section, we cover preliminary considerations, beginning with the definition of criminal law and an overview of related disciplines within criminal science, such as criminology and its branches, criminal policy, etiology, and criminal statistics. We now examine the rationale of penal law and the 2 major theories in criminal law. The classical theory emphasizes human free will as the basis of criminal liability and focuses on retribution, treating crime as a result of a moral choice rather than the criminal's nature. In contrast, the positivist theory views crime as a social and natural phenomenon. It suggests that criminals may be constrained by external factors, advocating for rehabilitation based on individual needs. Note that the Revised Penal Code is based mainly on the classical theory. This video continues with the definition of crimes. We look at felonies, offenses, and the infractions of ordinances. Importantly, we distinguish between these and note when a penalty imposed is not an exercise of sovereign power to define crimes and provide punishment. Moving to general principles, we discuss the state's power to punish crimes and apply laws in criminal cases. A key point is that there are no common law crimes in the Philippines. All crimes must be established by statute. We now explore the characteristic of generality in penal law. Under public international law, certain entities enjoy absolute exemption from criminal prosecution, including sovereigns, ambassadors, ministers, and foreign war vessels or military forces present in the country. Exemptions can also be relative, depending on specific treaty stipulations. While consuls and vice-consuls are often mentioned, honorary consuls are not generally accepted. We also acknowledge the role of international agreements, such as the Visiting Forces Agreement, in defining jurisdictional boundaries. Certain laws provide for preferential application. For instance, the 1987 Constitution grants members of Congress immunity from libel or slander regarding legislative speeches. Additionally, Republic Act No. 75 provides immunity for certain registered domestic servants of accredited ambassadors. Regarding military law, civil courts retain jurisdiction over offenses committed by military personnel when those courts are functioning and no actual hostilities are in progress. The military character of the offender does not automatically strip civil courts of their authority to try the case. The scope of military law encompasses various individuals, including members of the regular forces, reservists on active duty, trainees, and others lawfully drafted into service. These individuals are subject to the Articles of War under Commonwealth Act No. 408. Further categories of persons subject to military law include cadets, those accompanying the Army in the field during war or martial law, and individuals serving sentences adjudged by courts-martial. Civilians inducted into military authority may also fall under this jurisdiction. We now address the principle of territoriality. The general rule is that Philippine penal law applies within the Philippine territory, which encompasses its atmosphere, interior waters, and the maritime zone, as defined by the Constitution and administrative codes. In defining our waters, the law distinguishes between territorial waters, the contiguous zone, and the exclusive economic zone. These zones are defined by specific nautical mile measurements from the baseline, governed by international conventions like UNCLOS and national legislation. While territoriality is the rule, Article 2 of the Revised Penal Code provides exceptions for the extraterritorial force of penal laws. This includes offenses committed on Philippine ships, forgery of currency, or crimes against national security and the law of nations. Finally, we consider jurisdiction over crimes aboard foreign vessels. Warships are generally exempt, while for merchant vessels, this jurisdiction often follows the English rule, where crimes are triable unless they only affect the internal management of the vessel. This section discusses the application of penal laws to foreign vessels. Generally, if a vessel is merely in transit through Philippine waters, our laws are not applicable to offenses committed on board. However, if the ship is not in transit and is heading to a Philippine port, or if the crime is continuing while in our waters, local jurisdiction applies. We move on to the concept of extradition. Extradition is the surrender of an individual by one state to another state for prosecution or punishment for a crime. The Philippine extradition law is governed by Presidential Decree No. 1069, which outlines the formal procedures for this process. A foundational principle in our criminal system is the prospective nature of penal statutes. Criminal laws generally apply only to acts committed after they take effect. This is deeply rooted in the principle of legality, summarized by the Latin maxim nullum crimen nulla poena sine lege, meaning there is no crime or punishment without a pre-existing law. The Constitution prohibits the enactment of ex post facto laws and bills of attainder. An ex post facto law is one that makes an act criminal that was not punishable when committed, or one that aggravates a crime or increases its penalty retrospectively. Judicial rulings are generally not applied retroactively if it adversely affects the accused. While penal laws operate prospectively, there is an important exception. They apply retroactively if they are favorable to the accused. Examples include reductions in penalties, the elimination of an offense, the removal of subsidiary imprisonment for insolvency, or the introduction of new grounds for the mitigation or extinction of criminal liability. However, this favorable retroactive application has exceptions. It does not apply to an habitual criminal. Additionally, if a later statute specifically precludes application to pending cases, or if an accused expressly invokes a prior statute under which they were prosecuted, the retroactive benefit may be waived or barred. Article 22 of the Revised Penal Code, which allows for favorable retroactive application, also extends to special penal statutes. Courts have the authority to apply this principle sua sponte to ensure that an accused receives the benefit of a more lenient law passed after the commission of the offense. We must also note the rule of certainty. Penal laws must be clearly defined so that there is no ambiguity regarding what conduct is prohibited. This principle reinforces the prohibition against common law crimes in the Philippines, ensuring that criminal responsibility is only triggered by conduct specifically denounced by legislative act. Criminal liability is also strictly personal. One person cannot assume the criminal liability of another. Furthermore, our legal system explicitly rejects the concept of crimes by analogy. Conduct not specifically prohibited by a statute cannot be punished, even if it is deemed socially dangerous or similar to a forbidden act. Fundamental to penal law is the concept of free will. Liability presupposes that the individual was free to choose between right and wrong. Without this freedom of will, there can be no criminal liability. Furthermore, all are presumed to know the law. Ignorance of the law does not excuse anyone from compliance. In interpreting penal laws, the rule is to construe them liberally in favor of the offender and strictly against the state. This means any reasonable doubt as to the interpretation of a law should be resolved in favor of the accused, reflecting our system's emphasis on protecting individual rights against overreach. However, this rule of strict construction is not absolute. If the intent of the law is clear, or if a strict construction would defeat the manifest policy and purpose of the statute, the courts will adopt the interpretation that promotes the law's objectives. When two interpretations are possible, the one giving effect to the legislative intent prevails. When interpreting the Revised Penal Code, the original Spanish text is generally considered controlling over the English version. Regarding amendments and repeals, if a law is expressly repealed, the crime is effectively obliterated, and pending actions are dismissed, unless the repealing law provides otherwise or the accused is an habitual delinquent. We must also distinguish express repeal from implied repeal. Implied repeal is not favored and requires an irreconcilable inconsistency between the old and new laws. If an implied repeal occurs, pending criminal actions are not automatically dismissed. Rather, the penalty under the second law may be applied if it is more favorable to the accused. Finally, if a repealing law fails to penalize acts that were defined in the repealed law, courts are deprived of jurisdiction to continue trying or convicting persons charged with those prior offenses. This ensures that the state cannot prosecute conduct that has been decriminalized by the repeal. This section covers general principles regarding the revision and codification of penal laws. We discuss the necessity of harmonizing different legal provisions and the rule that an omission in a revision is deemed an implied repeal of the omitted provision. We continue with the effects of repealing laws on pending criminal cases. Furthermore, we emphasize the principle that all doubts in the interpretation of criminal laws or in the evaluation of inculpatory facts must be resolved in favor of the accused to ensure justice. This portion examines the date of effectiveness for penal laws. We discuss the history and rationale behind the Revised Penal Code and the procedural requirements for the effectivity of penal statutes, including the necessity of proper publication as established by jurisprudence. We now look at the application of the provisions of the Code. We explore the jurisdictional limits of the Philippines and the interplay between the Revised Penal Code and military law, noting that while concurrent jurisdiction often exists, war crimes remain a specialized category. Here we define the elements of a felony. A felony is generally composed of an act or omission that is punishable by law. We emphasize that only external acts are punished, and that the principle of nullum crimen, nulla poena sine lege governs all criminal offenses. Felonies are classified by the means of their commission into intentional and culpable felonies. Intentional felonies involve malice or dolo, while culpable felonies arise from imprudence, negligence, or a lack of foresight. Even without malice, a person may be held liable for culpable acts. When dealing with special laws, the requirement for malice differs from that of the Revised Penal Code. In crimes classified as mala prohibita, criminal intent is generally not required. The mere commission of the prohibited act is sufficient to incur criminal liability. While good faith is generally not a defense for mala prohibita offenses, there are exceptions based on government policy. However, the intent to perpetrate the physical act itself is typically necessary, even if the intent to commit a crime is not required by statute. Returning to dolo, the term is often improperly translated as deceit. Its true essential elements include freedom, intelligence, and intent. We distinguish these elements and note how they serve as the foundation for determining liability in intentional crimes. Intent is distinct from motive. While motive can aid in identifying an accused or establishing innocence, it is not an element of the crime. When the perpetrator is positively identified, the absence of an established motive does not necessarily lead to an acquittal. Continuing our discussion on motive, while it can be relevant in certain evidentiary contexts, proof of motive alone is never sufficient to support a criminal conviction. It serves only as a supporting element rather than a substitute for proving the commission of the act itself. There are instances where crimes are committed without specific criminal intent, such as in cases involving, quote, culpa, or specific statutory violations like the bouncing checks law. These illustrate the flexibility of criminal law application in diverse legislative contexts. Intentional and culpable felonies share the common requirement that the act performed must be voluntary. Even in negligent acts, the execution of the movement is considered voluntary. Criminal intent is typically inferred from the manifestation of the overt acts committed by the accused. Criminal intent is often presumed from the commission of an unlawful act. However, this presumption does not apply if the act itself is not inherently criminal, or if the imputation involves a matter of public interest protected by specific legal principles. Finally, we discuss how criminal liability is incurred, specifically focusing on defenses like mistake of fact. We differentiate between a true mistake of fact and, quote, error in persona, or mistake in the identity of the victim, which does not negate the criminal nature of the act. We continue our overview of the core syllabus with this video, which covers how criminal liability is incurred as outlined in Article 4 of the Revised Penal Code. It discusses committing a felony even when the consequences are unintended, including the requirement that the felony be committed and that the resulting wrong is a direct and logical consequence of that act. We continue exploring criminal liability, specifically focusing on the causal relationship between an act and the resulting death. This includes analyzing whether a blow was the efficient or proximate cause of death, and how that is legally determined. In certain situations, liability is affected by intervening causes. This includes scenarios where an injury is distinct from the felonious act, such as when the death is attributable to independent factors like local diseases, unproven causes, or other external medical conditions. We further examine intervening causes, such as instances where a blow might accelerate death. The legal analysis distinguishes between cases where the injury itself is not the primary cause of death versus instances where there is a clear, efficient intervening cause. Other factors influencing liability include the victim's temperament, inherent physical conditions, or potential neglect. This includes situations where a victim refuses medical attention or where medical intervention is later deemed unskillful, all of which are considered in assessing proximate cause. Liability can also be incurred even if the outcome was unintended. This includes legal concepts such as serror in personae, where the identity of the victim is mistaken, or aberratio ictus, where the blow misses the intended target. The law also addresses impossible crimes. These are acts that would have constituted a felony against persons or property had they been successful. The video lists several examples of such crimes against persons, including parricide, murder, and homicide. Beyond crimes against persons, the concept of impossible crimes also applies to property. This section categorizes offenses like a robbery, theft, usurpation, and arson, detailing the legal provisions and related statutes involved. Impossible crimes require evidence of evil intent, even if the act was not accomplished due to inherent impossibility or inadequate means. It is important to note that these acts are distinct, and there is no frustrated or attempted stage for impossible crimes. Article 5 of the Revised Penal Code defines the duty of courts. This includes cases where an act, though not explicitly punished by law, may still be deemed appropriate to repress, adhering to the principle of nullum crimen, nulla poena sine lege. The courts also carry a duty to enforce public policy and apply the law as written. This involves ensuring that penalties are not excessive and that judicial decisions align with established legal interpretations by the Supreme Court. It is noted that the duty of courts regarding excessive penalties is generally not applicable to special laws. However, there are area-specific applications in cases involving illegal possession of firearms or violations of dangerous drug acts, among others. We now turn to the phases in the commission of felonies, as defined by Article 6. These phases are divided into the subjective phase, where the focus is on the actor's intent, and the objective phase, which concerns the physical execution. The development of crimes begins with internal acts, which are not punishable. External acts are further broken down into preparatory acts, which are generally not punishable unless a specific law provides an exception, such as the possession of picklocks. In summary, the transition from internal thought to external execution marks the progression of a crime. Following preparatory acts, the law identifies acts of execution as the next critical phase in defining criminal liability. We now examine the consummated stage of felony execution. While Article 6 does not provide a strict rule, specific crimes like homicide or murder are considered consummated when death is produced, even if there was no initial intent to kill. In arson, a felony is consummated as soon as a portion of the structure begins to burn. For rape, legal precedents clarify that even slight penetration, without the necessity of rupturing the hymen, constitutes a consummated offense. Continuing with rape, legal authorities emphasize that penetration, rather than ejaculation, defines the crime. For theft, the felony is consummated when the unlawful taking is completed, placing the item under the offender's final control. Next, we look at the frustrated stage. In homicide or murder, a crime is frustrated if the wound inflicted is mortal, but death does not occur. In arson, it is frustrated when preparations to fire a building are ready, but no portion has burned. Regarding rape, the concept of frustrated rape is considered legally incongruous. Current anti-rape laws have moved away from this classification, as all necessary acts for penetration would complete the offense. In the context of theft, Supreme Court rulings have clarified that there is no crime of, quote, frustrated theft under the Revised Penal Code, as the unlawful taking does not require the offender to reach a state of free disposition of the stolen goods. We now address the attempted stage of felony execution. For a crime to be attempted, overt acts must have a direct connection to the felony intended. This is observed in cases where, for instance, a shot is fired with intent to kill but misses the target. In arson, an attempted felony occurs when there is an intent to set a building on fire, but no part of the structure has been ignited. Similar logic applies to various crimes, where intent is clear, but the execution is interrupted. The attempted stage also applies to crimes like theft and estafa. If the offender performs overt acts of deceit or theft but is prevented from completing the crime by external causes, the act is classified as attempted. Moving to Article 7, we discuss light felonies. The general rule is that these are only punishable when they are consummated. This includes minor offenses such as slight physical injuries, which were previously defined under the Code. Light felonies also encompass offenses like the alteration of boundary marks or malicious mischief. However, there are important exceptions to the general rule, particularly regarding crimes against persons and property, which may carry different liabilities. Regarding liability for light felonies, principals and accomplices are held accountable, while accessories are not. Examples include slight physical injuries or specific instances of theft, where the value of property stolen is very low. The criteria for light felonies also cover theft under specific conditions, such as gathering farm products on enclosed estates, provided the value is below the statutory threshold, and cases of malicious mischief where damage is minimal. Finally, we discuss Article 8, conspiracy and proposal to commit a felony. Generally, these are not punishable under Philippine law unless a specific statute explicitly provides for their criminalization, such as in cases of treason. Specific exceptions where conspiracy is punishable include treason, rebellion, and sedition. Understanding these distinctions is critical for determining criminal liability when multiple parties are involved in the planning stages of a serious offense. We now delve into Article 8 of the Revised Penal Code, focusing on conspiracy and proposal to commit a felony. Conspiracy is formed when two or more persons agree to commit a felony and decide to execute it, while proposal occurs when a person, having decided to commit a crime, proposes it to another. It is essential to distinguish conspiracy as a crime from conspiracy as a means to commit a crime. When conspiracy serves as a means, it essentially establishes the collective criminal responsibility for the offense. This leads to the principle: the act of one is the act of all, and conspirators can be held liable for the entire outcome. The degree of proof required to establish conspiracy is the same as that required for the crime itself, which is proof beyond reasonable doubt. It is important to note that mere companionship or presence at the scene of a crime is generally insufficient to prove conspiracy, unless such presence evinces a common culpable design. Evidence of conspiracy must be positive and convincing, founded on facts rather than mere conjectures or inferences. A conviction for conspiracy requires robust proof that satisfies the high standards of criminal prosecution to ensure that every participant is held responsible only for their proven involvement. Indicators of conspiracy often involve participation that furthers a common design. While direct proof of an agreement is not strictly essential, it can be inferred from the circumstances surrounding the act, showing a concurrence of sentiments and concerted action among the participants involved in the felony. Regarding desistance, any conspirator may abandon the criminal design before the act is actually committed. If the conspiracy is not established, liability remains individual, meaning each participant is only held responsible for their own specific actions during the commission of the offense. There are instances where mere conspiracy constitutes the commission of a crime, regardless of whether the planned felony was completed. Key examples under the Revised Penal Code include combinations in restraint of trade under the repealed Article 186, or its present counterpart of collusive agreements under the present Philippine Competition Act, brigandage, and specific violations under the Comprehensive Dangerous Drugs Act. We now look at the classification of felonies by gravity, as outlined in Article 9. Felonies are categorized as grave, less grave, or light, based on the penalties they carry. Grave felonies involve capital punishment or afflictive penalties, such as reclusion perpetua or prison mayor. Less grave felonies are those for which the law provides correctional penalties. These include prison correctional, arresto mayor, suspension, and destierro. This classification system helps the legal system apply appropriate penalties based on the severity of the offense committed. Finally, light felonies are those punished by arresto menor or a fine not exceeding a specific amount. The classification relies on the penalty prescribed by law. These minor offenses, such as certain cases of malicious mischief, are treated with lighter penalties to distinguish them from more serious crimes. Article 10 addresses offenses governed by special laws, which are generally not subject to the provisions of the Revised Penal Code. This means that attempted or frustrated stages of crimes defined in special laws are often not punishable unless the law explicitly states otherwise. However, there is an exception. The Revised Penal Code can supplement special laws. This occurs, for instance, when a special law's penalty is modified by a newer, more favorable law, or when the Code's general principles on liability are applied to clarify participation or confiscation of tools. In conclusion, supplementary application of the Code to special laws cannot occur if it is legally or physically impossible, or if the special law prohibits it. Courts carefully evaluate each case to determine when the Code's provisions provide necessary guidance to special statutes.
The Philippine Revised Penal Code of 1932 serves as the DNA of the nation's criminal justice system. It establishes the structural baseline for who faces punishment, how severe that penalty will be, and exactly why the state has the authority to impose it. To understand this code, you have to look at the era that built it. It was forged on the classical theory of criminal law, a system that functions like an industrial engine. This theory operates on a strict mathematical logic. It assumes every person possesses absolute free will, libre albedrío. When an individual chooses to commit a crime, the state applies a direct, mechanically proportionate punishment. The focus is entirely on the result of the act, demanding pure retribution for the choice made. Over time, legal philosophy introduced the Positivist Theory to handle human complexity. This perspective views crime as a social or natural phenomenon, arguing that human volition can occasionally be subdued by severe psychological or environmental constraints. While the text of the 1932 Code remains predominantly classical, modern Supreme Court jurisprudence actively injects positivist ideas. Recent rulings allow for rigorous psychiatric evaluations, recognizing that severe psychotic episodes can completely deprive an individual of their intelligence and free will at the exact moment of an offense. This diagram maps the architecture of the Code's first 10 articles. You see the explicit theoretical divergence at the foundation. From these theories, the law builds upward into general principles of jurisdiction and into the statutory mechanics of what constitutes a felony. Mastering Philippine criminal law requires understanding how this 1932 text is actively reinterpreted through modern jurisprudence to manage contemporary crime. The Code's authority relies on three jurisdictional axes. First is the generality principle, establishing who is subject to the state's penal power. Under Article 14, Philippine penal laws bind everyone living or sojourning within the territory, applying equally regardless of nationality, race, or creed. The only absolute exemptions to this rule exist through public international law. A foreign sovereign, a head of state, or a designated ambassador enjoys diplomatic immunity, shielding them from local prosecution. Yet this immunity has strict domestic limitations. It does not grant foreign actors or domestic politicians a limitless license for illegal behavior inside the host nation. When privileged actors step outside these boundaries, the courts apply the relevancy test. This mechanism evaluates the conduct of individuals claiming immunity regarding judicial decorum and defamatory statements. If a litigant inserts baseless slurs into a court pleading, the court evaluates whether those insults are legitimately related to the legal issue at hand. If they fail the relevancy test, the legal immunity is stripped away, and the author faces libel charges. The generality principle creates a uniform playing field of accountability. When diplomatic or legislative privilege is abused, the state's interest in maintaining public order outweighs individual immunities. The second axis is territoriality. This explicitly defines the physical and geographic boundaries where Philippine penal laws can be enforced. Following the UN Clause maritime framework, the state asserts absolute penal power over its landmass, its interior waters, and a territorial sea extending exactly 12 nautical miles from its baseline. A specific jurisdictional conflict triggers when a foreign merchant vessel, harrying foreign nationals, crosses into these Philippine territorial waters. International law offers two competing standards for this dilemma. The French rule dictates that the host state ignores crimes committed aboard foreign vessels, stepping in only if local peace and security are directly compromised. Contrastingly, the English rule takes the opposite approach. It asserts that the coastal state assumes full local jurisdiction over all crimes committed aboard the vessel, with an exception only for acts that strictly affect the ship's internal management. The Philippines strictly adheres to the English rule. If a crime occurs on a foreign merchant vessel passing through Philippine waters, it is triable locally. By enforcing the English rule, the Philippine state strategically prioritizes its national maritime security over the international principle of absolute navigational freedom. The third axis is prospectivity. It operates on the absolute legal principle of nullum crimen nolle poenus sine lege. There is no crime when there is no law punishing it. The state is constitutionally forbidden from enacting ex post facto laws. It cannot retroactively punish an individual today for an act that was entirely legal at the time of its commission. Under Article 22's favorable exception, if a new law reduces a penalty, the state bends time backward, applying leniency to past crimes. But this grace has a rigid limit. Retroactive leniency is strictly denied if the accused is classified as a habitual criminal. Prospectivity is a meticulously designed architectural safeguard. It balances the state's capacity to offer systemic mercy against its mandate to protect society from repeat offenders. Inside these jurisdictional boundaries, Article 3 outlines the precise mechanical construction of a felony. This document details the two methods of committing a felony. First is dolo, intentional execution requiring personal freedom, intelligence, and malicious intent. The second is culpa. Here, the felony occurs without malice, resulting instead from imprudence, negligence, or critical lack of skill. Under both the dolo and culpa frameworks, there is one foundational requirement. The physical act that caused the harm must be completely voluntary. Outside of the standard penal code is the overriding concept of mala prohibita. These are acts made illegal by special legislative statutes, rather than inherent immorality, like the illegal possession of a firearm. In mala prohibita offenses, proving complex criminal intent is irrelevant. The mere volition to commit the prohibited act instantly triggers liability. Classifying a crime by its required mental state is the algorithm the justice system relies on to legally distinguish a cold-blooded killer from a careless driver. Once the mental state is proven, criminal liability mathematically scales based on the chronological stages of a felony's execution, codified in Article 6. In the attempted stage, the offender begins overt acts toward the crime, but is interrupted by external causes before the execution is completed. In the frustrated stage, the offender performs every necessary act of execution. The felony still fails to produce a result, but strictly due to reasons independent of the offender's will. Finally, in the consummated stage, all elements necessary for the execution and accomplishment of the felony are fully present. Modern jurisprudence alters this structure for specific offenses. In the landmark case People v. Quinola, the Supreme Court established a legal fiction regarding the crime of rape. The frustrated stage simply does not legally exist. By eliminating the frustrated stage, the state uses a deliberate legal fiction to maximize the protection of a victim's integrity. It ensures that the moment the slightest physical violation occurs, the crime is legally consummated. This rigid mechanics of liability drastically expands when we look at the doctrine of proximate cause under Article 4. If your initial crime sets off a chain reaction, the law tracks back sequence all the way to its end. The core rule of causality dictates that an individual is legally liable for all direct, natural, and logical consequences of their felonious act, even if the final injury was unintended. This manifests in three specific variations of unintended liability: error in personae, where there is a mistake in the victim's identity; aberratio ictus, where a blow accidentally hits bystander; and praeter intentionem, where the resulting harm far exceeds what the offender actually intended. This leads to the legal paradox of the impossible crime. This occurs when the state punishes an attempt that was physically impossible to complete, or where the means used were entirely inadequate. The logic here is strictly analytical. For an impossible crime to exist, the actor must still possess an explicit evil intent to commit an offense against persons or property. The goal was physically impossible, but the intent was real. The doctrines of proximate cause and impossible crimes prove that the RPC ultimately targets the felonious spirit and social danger of the actor. The state suppresses criminal propensity by prioritizing public safety over literal physical results. How can a private citizen constitutionally defend themselves against a state apparatus that stretches criminal liability so aggressively? The first defense is the rule of lenity. This interpretive shield strictly dictates that all ambiguities in penal statutes must be construed against the state and liberally in favor of the offender. The final safeguard for the accused during a trial is the equipoise rule. This diagram illustrates the rule's mechanism. If raw evidence is susceptible to two equal interpretations, one pointing to guilt and the other to innocence, the court is constitutionally mandated to rule for an acquittal. The first 10 articles of the Revised Penal Code provide the structural algorithm for balancing public order against fundamental human rights. They function as a highly engineered, evolving system that defines the very architecture of Philippine justice.
Welcome to this video on The Living Blueprint, exploring the foundational mechanics of the Philippine Revised Penal Code, specifically Articles 1 through 10. This video examines the shift from the classical core's focus on absolute free will and retributive justice to the modern positivist integration, which considers social and natural factors alongside individualized psychiatric rehabilitation. Penal law's reach is defined by jurisdictional boundaries. It generally applies to everyone in the Philippines, with specific extensions for crimes committed abroad and protections against retroactive application, except when laws favor the accused. Under the English rule, which the Philippines follows, the state asserts jurisdiction over crimes on foreign merchant vessels in its waters, unless the incident is limited to internal ship management and does not affect the port's peace. Liability is determined by the framework matrix, distinguishing between intentional felonies, or dolo, culpable felonies or culpa, and mala prohibita, which are offenses created by special laws where only the voluntary act is required. Proximate cause links an original felonious act to its consequences. Even if the result is unintended or involves an error in identity, the chain of liability often holds, as intermediate events rarely sever it. An impossible crime occurs when the offender has evil intent but fails to complete the act due to inherent impossibility or inadequate means. In these cases, the law focuses on the actor's criminal propensity. A crime proceeds through stages: preparatory acts, the subjective phase where overt acts begin, and the objective phase. Once the desistance threshold is passed, the offender loses control over the outcome. Defining these thresholds is critical. For instance, a mortal wound can transition an act into the objective phase, while certain crimes, like rape, have specific legal definitions regarding when they are considered consummated. Conspiracy requires more than just meeting. It necessitates a physical, overt step in furtherance of the crime. Modern rulings emphasize this, while also allowing courts to infer common design from concerted physical action. The law provides safeguards for the accused, including the rule of lenity, which interprets ambiguous laws in favor of the offender, and the equipoise rule, which dictates acquittal when evidence is balanced between guilt and innocence. In summary, the Philippine Revised Penal Code acts as a living architecture, balancing the state's absolute power to punish with the fundamental rights of individuals through ongoing modern interpretation.
Let's dive right into this explainer and uncover exactly how a 1930s-era legal code still serves as the living, breathing foundation of modern Philippine justice. Today, we're cracking open the first 10 articles of the Philippine Revised Penal Code. Now, it's pretty common to mistake this document for some static relic of a bygone era. But as you're going to see, it's actually a highly sophisticated architecture, one that the Supreme Court is constantly modernizing to balance state power with your individual rights. To understand just how fascinating this legal framework really is, let's start with the slightly morbid hypothetical. Imagine creeping into a room fully intending to commit a cold-blooded murder. You fire a bullet directly into the heart of your target, only to discover a bizarre twist of fate. They had actually died of a heart attack an hour earlier. Crazy as it sounds, under the Philippine legal system, this literal mistake in physics wouldn't necessarily get your case dismissed. You could actually still face prison time. This totally counterintuitive reality introduces us to what Article 4 calls the impossible crime. In these highly unique situations, the state isn't punishing you for the physical harm you caused because, well, the act was inherently impossible to complete anyway. Instead, the focus shifts entirely to your intent. Whether you shoot a corpse or try to poison someone with plain sugar because you genuinely thought it was arsenic, the law says you're still a threat. The justice system is essentially punishing the felonious spirit and the evil intent that you demonstrated to society. Here is our agenda for today's explainer. We'll start with the architecture of justice, move on to the anatomy of a felony, explore the limits of sovereign reach, discuss collective guilt and fictions, and wrap up with interpreting the scales. Starting with Part 1, the architecture of justice. Think of the entire criminal law system as a giant structural blueprint. Everything from the broad strokes of liability down to the granular mechanics of a crime and the territorial reach of the law are all intricately connected. This isn't just a random list of rules, it's a meticulously structured mechanism. And at the very heart of this blueprint, the code is locked in a constant balancing act between two competing legal philosophies. On one side, you have the dominant classical theory. This assumes we all have absolute free will to choose between good and evil, and it demands strict mechanical retribution when we make bad choices. Pushing against that, though, is the modern Positivist Theory, which views crime more as a social phenomenon, emphasizing psychiatric investigation and rehabilitation. We actually see this playing out today in modern Supreme Court rulings, where severe psychotic episodes can lead to an acquittal, which really proves the system is adapting to our modern understanding of mental health. Moving right along to Part 2, the anatomy of a felony. Under Article 3, a felony basically happens in one of two ways, through dolo or through culpa. Dolo means you act with deliberate malice, deceit, and clear intent, like meticulously planning a bank robbery. Culpa, on the flip side, means your voluntary act caused unintended harm simply due to sheer negligence, imprudence, or lack of skill. Think of a reckless driving accident. Your act of driving was voluntary, sure, but that resulting injury, completely unintended. To truly grasp how liability works, we also have to separate crimes into two very distinct categories. First up are mala in se acts. These are crimes that are inherently evil and immoral in and of themselves, things like murder or theft. For these, the state absolutely must prove criminal intent for conviction. Second, we have mala prohibita acts. These are actions that are only illegal because a special statute says they are, like carrying a firearm without a license. For these, your good faith or lack of criminal intent is totally irrelevant. Merely committing the prohibited act voluntarily is enough to get you convicted. Now, when we break down the real-world timeline of a crime, Article 6 lays out three clear stages of execution. First is the attempted stage, where overt acts are begun but interrupted. Second is the frustrated stage. This is where the offender performs every single act necessary to commit the crime, but the felony just isn't produced due to outside causes. And finally, the consummated stage, where every element is fully present and the crime is accomplished. But here is a surprising reality check on how the law adapts to protect human dignity. In Philippine law, frustrated rape is a legal fiction. It simply does not exist. To protect the victim's integrity, the courts have strictly ruled that the absolute slightest physical contact immediately consummates the crime. There is no middle ground here. The very moment a violation begins, the crime is viewed as 100% complete in the eyes of justice. So what happens when things go wrong during a crime? That brings us to the role of proximate cause. This means you are legally responsible for all the direct, natural, and logical consequences of your felonious act. Let's say you intend to harm person A, but you miss and accidentally hit a bystander, a concept the law calls aberratio ictus, or a mistake in the blow. Well, you are still fully liable for the injury to that bystander even though you totally didn't intend it. It's a domino effect of liability. To keep all this organized, Article 9 cleanly splits offenses by gravity. It's a strictly graded mechanical system ranging from grave felonies, which carry heavy, afflictive penalties like life in prison, down to less grave felonies, and finally, light felonies, which might result in just a minor fine not exceeding 200 pesos. Let's move to Part 3, the limits of sovereign reach. Because the Philippines is an archipelagic nation, protecting its waters is a massive priority. So when a foreign merchant vessel enters Philippine territorial waters, whose laws actually apply? The Philippines asserts its maritime sovereignty by using what's called the English rule. Unlike the French rule, which basically tells host states to stay out unless their peace is actively disturbed, the English rule dictates that almost any crime committed on that foreign vessel is triable right there in local Philippine courts, unless it only affects the internal management of the ship itself. Now, while the generality principle states that penal laws bind almost everyone living or traveling inside the country's territory, with just a few exceptions for folks like heads of state or specific diplomats, Article 2 allows the law to remarkably reach beyond its own borders. The state can prosecute extraterritorial crimes like counterfeiting Philippine currency abroad or committing piracy on the high seas. This isn't just about handing out punishments, it is an absolute strategic necessity to protect national security and economic stability from afar. Which brings us to Part 4, Collective Guilt and Fictions. Under Article 8, we find the famous rule of conspiracy, which plainly states that the act of one is the act of all. If a conspiracy is proven, every single participant shares equal liability. However, modern Supreme Court rulings have definitely refined this. You can't get locked up just for being in the room. The court now strictly requires an actual physical overt act in furtherance of the crime. This proves that mere silent approval, or just being present at a sketchy meeting, is no longer enough to establish collective guilt. Surprisingly, the justice system can also kind of time travel. As a general rule, laws only move forward, meaning you can't be punished today for something that was totally legal yesterday. But there is a favorable exception. New laws can apply retroactively to past crimes if they are favorable to the accused, like, say, reducing a penalty or offering community service instead of a jail sentence. But there's a huge catch here. The state absolutely refuses to grant this grace if the offender is a habitual criminal. Finally, let's wrap up with Part 5, Interpreting the Scales. The foundational bedrock of how courts interpret all of this comes down to an ancient Latin maxim, nullum crimen nulla poenas sine lege. Literally translated, there is no crime when there is no law punishing it. It is the ultimate constitutional shield against state overreach. It guarantees absolute certainty, making sure the government cannot arbitrarily punish you for an act that wasn't strictly and legally defined as a crime at the exact moment you committed it. And this brilliantly highlights the system's built-in fail-safes. When interpreting ambiguous statutes, the rule of lenity forces courts to construe laws strictly against the state and liberally in favor of the offender. On top of that, if the evidence presented in a trial is perfectly, equally balanced between guilt and innocence, the equipoise rule mandates that the scales of justice must tip toward freedom and acquittal. Oh, and here's a fascinating historical quirk. If there is ever a translation conflict in court, the original 1930s Spanish text of the code remains the ultimate controlling authority. When you step back and look at this interconnected web of criminal law principles spanning Articles 1 through 10, you can truly appreciate the depth of this system. From the sweeping concepts of territoriality all the way down to the microscopic definitions of intent, this seemingly static 1930s document is actually a constantly evolving DNA sequence. It's carefully calibrated to balance immense state power with your vital individual rights. So as the Supreme Court continues to modernize this colonial-era code every single day, integrating our evolving understandings of mental health and human rights, we are left to ponder a massive philosophical question. In our ultimate quest for justice, should we continue to cling to the strict mechanical retribution of the past, or should we fully embrace a positivist future focused on psychiatric rehabilitation? It's a question the courts have to answer daily, and one that defines the very soul of the justice system. Thanks for joining me on this explainer, and keep questioning the structures around you.
So I want you to imagine creeping into a dimly lit room in the dead of night.
Okay, setting the scene. I like it.
Right, so you have this plan. It's this highly calculated, terrible plan. You are intending to commit cold-blooded murder.
Oh, wow. Straight into the heavy stuff.
Yeah, we're going right there. So you've stalked your target, you know their schedule, and you find them exactly where you expect them to be, sleeping soundly in their bed.
Okay.
Your heart is pounding, you raise your weapon, you take a breath, and you fire a single bullet directly into their chest.
Right.
And then you slip back out the window, completely convinced you have just pulled off this perfect, untraceable crime.
I mean, it sounds like every true crime documentary ever.
Exactly. But then, a few days later, the autopsy report gets leaked to the press, and you discover something entirely mind-bending.
Which is?
The medical examiner concludes that the person had actually died of a massive, sudden heart attack a full hour before you even set foot inside that room.
Ah, right. It is the ultimate mistake in physics. You cannot kill something that is already dead.
Which, that seems like common sense, right? And if you look at how this bizarre, morbid scenario plays out in many legal systems around the world, it often just gets thrown out of court.
Yeah, usually.
Like a judge looks at the facts and says, well, the object of the crime was non-existent. You fired a gun into a corpse.
Right. A literal impossibility.
Yeah, it's a physical impossibility to murder a dead body. Case dismissed. But if you attempt this exact same scenario in the Philippines, operating under a penal code that was drafted nearly a century ago, you are not walking free. You're still going to prison.
Which, honestly, that outcome completely shatters our intuitive understanding of cause and effect in a courtroom.
Seriously.
Because, we are wired to believe that you are punished for the damage you cause. No damage, no punishment. But the Philippine system asks a very, very different question in that scenario.
And that counterintuitive reality is exactly what we're dissecting today. So, welcome to this deep dive into the foundational architecture of the Philippine Revised Penal Code.
Or just the RPC, as the legal community calls it.
The RPC, right. Specifically, we're zooming all the way in on Articles 1 through 10. Now, I know the immediate thought here, like, a legal code written and enacted in 1932 sounds like this dusty colonial relic.
Right. You picture decaying parchment and laws about, stealing horses.
Yeah, exactly. But as we comb through our sources today, it becomes incredibly clear that this 1932 document is the invisible, living DNA of a highly complex modern justice system.
It really is.
Okay.
And to grasp what is happening here, we have to look at the sources we're working with.
Right. Let's lay those out.
So we have a very comprehensive, rigorous legal syllabus authored by Lorenzo Padilla, which, lays out the black letter law.
Okay.
But we are pairing that with these highly technical white papers that dissect the jurisdictional reach of these laws across international borders.
Which gets wild, by the way.
Oh, totally wild. And then we're layering in journalistic legal analysis from a series called Beyond the Gavel.
So we've got a lot of angles on this.
Yeah, and this combination prevents us from just, reading a textbook. We get to actually see the friction between the theory of the law and the messy reality of human behavior.
And that friction is the core of this entire discussion, because before we can even begin to categorize specific actions, before we can define what makes a theft, or what constitutes treason, or why shooting a corpse lands you in a jail cell, we have to confront a much more terrifying fundamental concept.
Which is the philosophy of state violence.
Exactly. Why does a government, consisting of flawed human beings, believe it possesses the ultimate moral and legal authority to take another human being, strip them of their freedom, and lock them in a cage for decades?
That is the existential question of criminal law. When we talk about the state's power to punish, we are talking about an awesome, terrifying monopoly on violence. And the RPC doesn't just have one simple answer to why it exercises that power. According to the foundational text, the RPC is actually the battleground for a massive, ongoing, philosophical tug of war.
Two competing theories of human nature baked right into the text.
Exactly.
Let's start with the one that forms the bedrock of the 1932 code, which is the classical theory. When I was reading the syllabus, the classical theory felt, incredibly rigid.
It is.
It basically views you, the citizen, as a perfectly rational, moral creature operating in a vacuum.
Yeah, and the historical context is crucial here. The RPC was heavily influenced by the old Spanish Penal Code, which itself was deeply intertwined with Catholic theology and classical philosophy.
Okay, so a lot of moral absolutes.
Right. So the central pillar of the classical theory is the concept of absolute free will. The original Spanish texts refer to it as libre albedrío.
Meaning you are the absolute master of your own destiny, like every choice is a conscious one.
Precisely. The state presumes that you possess the intellect to distinguish right from wrong and the absolute unencumbered freedom to choose between the two.
Right.
Therefore, if you commit a crime, the classical framework does not see a victim of circumstance. It sees a moral actor who looked at good and evil and actively chose evil.
And because of that free, calculated choice, the state's response is entirely mechanical.
Yes. It demands retribution.
It demands that you balance the cosmic scales. You cause this amount of pain to society, so society is going to inflict this proportionate amount of pain onto you.
Exactly.
Reading this, the classical theory feels less like a system of justice and more like a vending machine.
A vending machine.
Yeah, like you put a specific crime into the slot at the top, the gears turn, and a mathematically proportionate predetermined punishment drops out of the bottom.
That's actually an incredibly apt analogy.
Because it doesn't seem to care if you committed the crime because you were starving, or because you had a terrible upbringing, or because you were in a state of deep grief.
Wow.
You did the math, you made the choice, you get the penalty.
Right, because the classical theory focuses almost entirely on the objective result of the felonious act. It pays very little regard to the human element or the nuances of the psyche or the environmental pressures surrounding the offender. It is a system built on rigid mathematical retribution.
But, I mean, the 1930s were a long time ago, and our understanding of human psychology has exploded since then.
Oh, absolutely.
Which brings us to the second force pulling on the rope in this tug of war, the Positivist Theory. And this approach is actively pushing back against that cold, mechanical vending machine logic.
Yes, and the positivist perspective, which gained massive traction with the Italian School of Criminology, completely flips the script on human agency.
How so?
It argues that crime is not simply a cold, calculated moral choice. Instead, it views crime as a social, environmental, or even a morbid psychiatric phenomenon.
Yeah.
The positivist theory recognizes that human beings do not exist in a vacuum. Sometimes a person is subdued by strange, overwhelming forces that are entirely beyond their control.
So we're talking about things like poverty, systemic abuse, severe mental illness, forces that essentially hijack your libre albedrío, your free will.
Exactly. And if your free will is compromised or hijacked, well, the vending machine model of retribution becomes deeply unjust.
Because you didn't really have a choice.
Right. So under the positivist lens, the goal of the justice system shouldn't be to blindly inflict pain to balance the scales. The courtroom should function more like a diagnostic clinic.
Ah, okay.
The goal is psychiatric investigation, understanding the root sociological causes, and ultimately rehabilitation. You don't punish the act, you treat the actor.
Which honestly creates an administrative nightmare. If the classical theory treats the judge like a human calculator, the positivist theory demands the judge act like a social worker, a psychiatrist, and a sociologist all rolled into one.
It's a huge burden.
Yeah. So how does the Philippine Supreme Court, operating a code built on classical retribution, integrate this positivist need for rehabilitation? Because they can't just throw the 1932 code away, right?
No, they can't throw it away, but they can interpret it. The tension you were describing is the exact tightrope that Supreme Court justices walk in their rulings every single day.
Right.
The Philippine system remains predominantly classical. We still have strict penalties and prison terms, but it increasingly integrates positivist elements. And the most vivid, high-stakes battleground for this philosophical war is the insanity defense.
The insanity defense is so fascinating because it's where the law is forced to confront medicine directly.
Exactly.
Let's trace how the Supreme Court handles this, starting with the strict classical baseline. Our legal syllabus points to a 2017 case, People v. Roa. And this ruling felt very traditional, very anchored in the idea that everyone is sane until definitively proven otherwise.
ROA establishes a deliberately high barrier. I mean, the state knows that if the insanity defense is too easy to claim, it just becomes a get-out-of-jail-free card for everyone.
Right, everyone would just say they were insane.
Exactly.
Yeah.
So in ROA, the Supreme Court reiterated that to be completely exempt from criminal liability due to insanity, there must be a total, complete deprivation of intelligence, reason, or freedom of the will.
Not just feeling depressed or being impulsive,
Yeah.
like a total blackout of reason.
A total blackout. But the true classical kicker in ROA is the timing. That total deprivation of intelligence must exist at the exact, precise moment the crime is committed.
Which sounds nearly impossible to prove. The judge isn't in the room when the trigger is pulled.
Right.
Like in Roa, the defense argued that the accused had previous psychiatric diagnoses and a history of mental health struggles. They tried to use that past medical history as a shield.
They did.
But the court essentially said, we don't care if you were legally insane a week ago or a month ago. Were you legally insane in the millisecond you decided to strike?
Yes.
And because the defense couldn't prove that exact temporal link, the state presumed the offender was a rational moral actor.
That is the classical foundation at its most uncompromising. The burden of proof is entirely on the accused to prove they lacked free will at the moment of execution.
Right.
However, if we move the timeline forward just a few years, we see a massive positivist integration happening in real time.
Yeah, this part is wild.
The white papers highlight a groundbreaking 2024 case, Ruiz Serrano v. People.
When I read the breakdown of Ruiz Serrano, I actually had to read it twice, because the court's approach here feels like a 180-degree turn from the rigidity of Roa.
It really is.
Walk us through what happened in 2024.
So the accused in Ruiz Serrano was facing very serious homicide charges. The narrative was that she had suffered a severe psychotic episode, plagued by intense, terrifying delusions and hallucinations right at the time of the incident.
Okay.
Now, under the traditional ROA standard, proving that level of total mental deprivation without a massive stack of prior, long-standing medical and psychiatric records would be nearly impossible. The court usually demands a documented history of insanity to even entertain the defense.
Because without prior medical records, the prosecution can just argue she's making up the hallucinations after the fact to avoid prison.
Right. That is the standard prosecutorial counterattack. But in this 2024 ruling, the Supreme Court took a profound positivist leap. They looked at her immediate post-crime behavior and her descriptions of her delusions.
Okay.
The court admitted her statements about these hallucinations as what the law calls independently relevant statements.
What does that mean, practically?
They used the internal logic of her delusion to establish her actual compromised mental state at the exact moment of the crime. And crucially, they did this without requiring an extensive history of prior medical records.
They trusted the psychiatric reality of the moment over the bureaucratic requirement for past paperwork. That's huge.
It is huge.
And the result, she was acquitted, wasn't she?
She was completely exempted from criminal liability.
Right.
The Supreme Court acknowledged that acute mental health crises, like a sudden psychotic break, are morbid phenomena that can entirely subdue a person's free will without warning. They recognize that a person trapped in a hallucination has lost their libre albedrío.
Because they literally can't see reality.
Exactly. They cannot choose between good and evil because their perception of reality is fundamentally broken. Therefore, retribution serves absolutely no purpose.
That is a staggering shift in jurisprudence. It really shows the court actively downloading a modern understanding of acute psychiatry into the 1932 operating system.
That's a great way to put it.
But it also raises a gray area. We have ROA, where you are totally sane, and Ruiz-Serrano, where you are totally deprived of reason.
Right.
What happens if an offender falls somewhere in the middle? Like, what if a person has severe mental health issues, maybe a history of schizophrenia, but they aren't completely deprived of reason during the crime? They know on some level that what they are doing is wrong, but their willpower is severely eroded.
Well, the law does not ignore the gray areas. And this brings us to the Pantoja case.
Okay.
In Pantoja, the court clarified how to handle diminished capacity. If an offender has documented mental oddities or even a history of prior confinement in a psychiatric facility, but the evidence shows they still retained a functional level of reason and discernment during the actual commission of the act.
Meaning they knew what they were doing.
Right. They do not get the full exemption we saw in Ruiz-Serrano.
So they don't get acquitted. The classical machine still demands its pound of flesh.
Yes. The classical need for retribution remains because some fraction of free will was exercised. The offender will go to prison. However, the court applies a brilliant positivist compromise here.
Oh.
It treats the diminished willpower and the psychiatric history as a mitigating circumstance.
Meaning the baseline penalty drops?
Exactly. You are punished, but your penalty is significantly reduced. The court recognizes your psychiatric reality and adjusts the math of the vending machine.
That's so interesting.
It really is. It is the perfect distillation of the Philippine system, a classical foundation of punishment, tempered by a positivist application of mercy and scientific understanding.
It's an incredibly elegant way to balance two completely opposing philosophies. Okay, so we spent time unpacking the why. We understand that the state punishes to exact retribution for bad choices, but increasingly looks to rehabilitate those whose choices were compromised.
Right.
Now, we need to map out the logistics. We need to ask who exactly is subject to this terrifying power, and where do the physical boundaries of that power stop?
So the logistical reach of the law begins with a concept known as the generality principle. You will find this embedded in Article 14 of the Philippine Civil Code, but it is the absolute bedrock of criminal jurisdiction.
Okay.
The generality principle is remarkably sweeping. It declares that penal laws bind absolutely everyone who lives or sojourns in the Philippine archipelago.
Sojourns being the operative word there, it means temporary visitors.
Yes. It does not matter what passport you hold, what your nationality is, what your race or creed is. If you are a tourist who has been in Manila for 3 hours on a layover and you commit a crime, the generality principle dictates that you are fully bound by the Revised Penal Code.
Got it.
If your feet are on Philippine soil, the law applies to you.
It's a blanket of jurisdiction, but of course in law, there's always a hole in the blanket.
Always.
There are always exceptions. So who gets to stand on Philippine soil and basically say, hey, your laws don't apply to me?
The exceptions are carved out by public international law. Absolute immunity from local criminal jurisdiction is granted to sovereigns or sitting heads of state, as well as ambassadors and ministers plenipotentiary.
Okay, let's clarify ministers plenipotentiary for a second, because that sounds like a title from a fantasy novel.
It really does. It is an older diplomatic term, but it essentially refers to high-ranking diplomats who are invested with the full power and authority to represent their head of state in a foreign nation. Because they are the literal embodiment of a foreign sovereign, arresting them would be tantamount to an act of aggression against that foreign state. Similarly, foreign war vessels and foreign armies that are formally permitted to enter the territory are generally exempt from local police powers, governed instead by specific treaties or the laws of their flag state.
Okay, so international diplomacy creates a shield. But what about domestic shields? Because I know under the 1987 Philippine Constitution, members of Congress have parliamentary immunity.
They do.
They cannot be arrested for or charged with libel or oral defamation for any speeches or debates they make while Congress is in session. The logic being, lawmakers need absolute freedom to debate controversial policies without the chilling effect of facing a lawsuit every time they open their mouths.
That is a highly functional domestic exemption. It protects the institution of the legislature. But the limits of domestic privilege are constantly being tested, particularly within the legal profession itself.
And this is where the syllabus brings up a case that I found absolutely wild. It tests the boundaries of what lawyers can get away with under the guise of legal privilege. Let's look at the 2017 case, Beelan v. People.
Beelan is a masterclass in understanding how the generality principle pushes back against attempts to stretch exemptions too far. In this scenario, we have a lawyer who is acting as a litigant, filing a formal judicial pleading a written legal argument in court.
Okay.
Now, the baseline rule is that statements made by lawyers in official judicial pleadings are considered absolutely privileged communications.
Right, similar to the lawmakers in Congress. The system recognizes that lawyers have to be zealous advocates. If you are defending a client, you might need to accuse a witness of lying or accuse a corporation of fraud.
Exactly.
If you could be sued for libel for every aggressive claim you make in a court document, the justice system would grind to a halt. Lawyers would be too terrified to actually argue their cases.
Precisely. The privilege exists to protect the machinery of justice. But the lawyer in the Beelan case decided to stretch that privilege past its breaking point.
Oh boy.
He didn't just argue the law or present aggressive facts. He used his official judicial pleading to hurl wild, deeply personal, and completely baseless insults at the opposing prosecutor.
I read the excerpts in the syllabus. He didn't just use subtle legal shade. He literally put in the official court record that the prosecutor was an idiot and described his actions as moronic.
He weaponized the legal document.
Like he literally wrote idiot.
Yes, idiot and moronic. And when the prosecutor inevitably filed charges for libel and oral defamation, the lawyer attempted to use the generality principle's domestic exemption as an impenetrable shield.
Of course he did.
He argued that because the insults were written inside a judicial pleading, they were privileged, and the state could not punish him.
He essentially said, I'm in the safe zone. You can't touch me. So how did the Supreme Court dismantle that argument?
The Supreme Court instituted what they call the relevancy test. They ruled that legal privileges are not a blank check to abandon basic human decency. For a statement in a pleading to be protected by privilege, it must be relevant and pertinent to the actual legal issues being litigated in the case.
So if the case is about a property dispute, calling the prosecutor an idiot doesn't help resolve who owns the land.
Exactly. The court determined that the generality principle's exemptions do not grant anyone a license to insult because his slurs were completely untethered from the legal arguments and served no purpose other than malicious defamation. The shield of privilege evaporated.
Wow.
His immunity was stripped, and he was held fully liable under the Penal Code.
I love the relevancy test. It perfectly balances the need for zealous advocacy with the requirement for professional decorum. Like, you can swing the sword of justice, but you can't just throw mud.
That's a good way to look at it.
So that covers the who. We know the law applies to everyone except a tiny fraction of diplomats and protected speech. But immunity isn't just about your job title, is it? It's also about where your feet are physically planted. Which brings up a massive logistical nightmare for an archipelagic country like the Philippines. Let's move from generality to the territoriality principle.
So the territoriality principle defines the physical container in which the state exercises its awesome power. The law is geographically bounded. It stops at the physical borders of the Philippines, which includes its terrestrial landmass, its atmospheric airspace, its interior waters, and its maritime zone up to the internationally recognized limits.
Okay.
Inside this three-dimensional space, the state exercises absolute, unquestioned penal power.
But the borders of any country are porous. People are constantly flowing in and out, and this creates incredibly high-stakes scenarios at the entry points, specifically at ports and airports.
Oh, absolutely.
The tension here is palpable. On one hand, you have the state's desperate need to maintain border security and keep out contraband. On the other hand, you have a citizen's constitutional right to privacy and protection against unreasonable, warrantless searches.
Right. It's a huge balancing act.
The white papers map out a few key Supreme Court rulings that navigate this exact tension. Let's start with the anxiety of airport security and the Canton case.
Anyone who has flown commercially understands the intrusive nature of airport security. In People v. Canton, the Supreme Court had to decide if that intrusion violates the Constitution. The court ultimately upheld routine airport security frisking as a valid, universally accepted exception to the requirement for a judicial search warrant.
They reason that when you buy a ticket and enter the terminal, you are implicitly agreeing to a reduced expectation of privacy in exchange for the safety of the flight.
Correct. The state's interest in preventing hijackings or terrorism at its aerial borders outweighs the individual's right to absolute privacy. Therefore, if you were passing through an airport magnetometer and during a standard routine frisk, the security personnel find illegal drugs or an unlicensed weapon strapped to your leg, that evidence is fully admissible in court. The search is completely lawful.
And it's not just physical frisking, it's the technology we submit to. The 2016 case of Erwin Lebo on Dela Cruz v. People tackled the X-ray machines. We all heave our bags onto that conveyor belt without thinking twice about the legal implications.
Yes, and Dela Cruz clarified the sequence of events that makes an X-ray search valid. The court ruled that when an X-ray scanner detects the opaque outline of something that looks like contraband, say, the unmistakable silhouette of a firearm, that image alone creates immediate, actionable, probable cause for the security officers.
But they still need to open the bag. Does the X-ray image give them the right to rip your luggage apart without asking?
Technically, procedure requires them to ask. But in Dela Cruz, the court noted that when confronted with the X-ray findings, if the passenger voluntarily opens their bag for physical inspection or hands over the keys without objection, they have given valid, informed consent.
Consent is key.
Right. By consenting, they completely waive their right to a warrant, and any contraband found is admissible.
So airports are zones of highly expanded state power, but the state's power at the border isn't infinite. There is a breaking point where the Supreme Court will slam the brakes on law enforcement, and our sources point to the Chua Hosan case as a massive stop sign.
Chua Hosan is a critical counterweight to the airport cases. This case involved a warrantless search at a maritime port of entry. The police intercepted an individual based on a vague tip and proceeded to search his baggage without a warrant, ultimately finding illegal drugs.
Okay.
The state tried to argue border security, but the Supreme Court rejected it.
Why? What made the port search in Chua Hosan illegal when the airport search in Canton was fine?
It comes down to the mechanics of probable cause and the nature of the stop. Routine airport screening applies to everyone equally before they enter a secure zone.
Everyone goes through the metal detector.
Exactly. But in Chua Hosan, the officers targeted a specific individual without a warrant. The court ruled that police officers cannot simply stop and search your baggage on a whim or based on an unverified rumor.
So they need more than just a guess.
Much more. Unless the officers have personal knowledge that a felony is actively occurring, meaning they literally observe you committing a crime, or they have overwhelming articulable facts in that exact moment, a targeted warrantless search is unlawful.
The police can't just operate on a hunch and hope they get lucky. And if they do operate on a hunch, they search your bag illegally, and they actually find a massive brick of illegal drugs, what happens to the drugs?
The drugs become legally invisible. Under the exclusionary rule, any evidence obtained through an unlawful search becomes completely inadmissible in court. It is classified as the fruit of the poisonous tree. The state cannot use the results of its own constitutional violation to secure a conviction. The territoriality principle gives the state vast power, but Chua Hosan proves that this power is strictly bounded by the ironclad rules of constitutional due process.
I want to linger on the maritime aspect here, because the Philippines is an archipelagic nation made up of over 7,600 islands.
Yes, that is.
We are defined by water. Our borders are largely liquid. So imagine this scenario. A massive foreign-flagged merchant vessel, let's say it's registered in Panama, floats into Manila Bay. It is sitting in Philippine territorial waters.
Okay, so I picture it.
Suddenly, a violent crime occurs on board the ship. 2 sailors get into a brawl that ends in a stabbing. Who takes charge? The Manila police or the country whose flag is painted on the side of the ship?
You have just highlighted a classic long-standing dilemma in public international law. When a foreign vessel enters coastal waters, 2 sovereignties overlap. To resolve this, international law developed 2 competing doctrines, the French rule and the English rule.
Let's start with the French rule. Why would a country adopt it?
The French rule essentially tells the coastal state to mind its own business. It dictates that the coastal state assumes absolutely no jurisdiction over crimes committed on a foreign merchant vessel unless the crime actively disturbs the peace and security of the port itself.
Okay, so it's quiet. They don't care.
Right. France, historically being a massive continental power with secure land borders and specific localized port cities, preferred this approach. If 2 foreign sailors stab each other below deck and the noise doesn't bother the dock workers in Marseille, the French authorities leave it to the ship's captain to handle under the laws of their flag state.
It's a very hands-off approach. As long as you don't spill blood on our docks, we don't care. But the Philippines, being an archipelago, does not follow the French rule. We follow the English rule. Why?
The geography demands it. Unlike France, the Philippines does not have a solid continental landmass. Its internal waters, straits, and bays are the very arteries of the nation. A crime committed on a ship in the Cebuan Sea isn't happening on the periphery. It is practically happening in the heart of the country.
That makes total sense.
Therefore, under the English rule, the coastal state, the Philippines, assumes aggressive primary jurisdiction over all crimes committed aboard the foreign vessel while it is in our territorial waters.
The only exception being if the act affects only the internal management of the ship, like a dispute over a sailor's wages or sleeping arrangements. But if it's a felony, the Philippine police are boarding the ship.
Precisely. The English rule is a robust assertion of sovereignty. If you are in our water, you are under our law, period.
And this assertion of sovereignty isn't just academic posturing. The syllabus brings up a case that shows how violently the state will defend its waters, the case of People v. Catintan.
Catintan is a thrilling and terrifying application of maritime jurisdiction. The facts are stark. Heavily armed men forcibly boarded a small, motorized fishing pump boat while it was navigating in municipal waters. Using the threat of their weapons, they took complete control of the vessel and forced the fishermen to alter their course.
Now, if you look at this through the lens of a land-based crime, if someone jumps into your car at a stoplight with a gun and forces you to drive them somewhere, we usually call that kidnapping, or grave coercion, forcing someone to do something against their will.
Right.
I would assume the state would charge these men with grave coercion or perhaps armed robbery.
And the defense actually attempted to argue for those lesser charges. But the state refused to view the crime through a land-based lens. They looked at it through the doctrine of absolute maritime security. The prosecution did not charge them with mere coercion, they charged them with piracy.
Piracy, like the crime of the high seas.
Yes. The Supreme Court upheld the conviction for piracy, ruling that the lesser localized crime of grave coercion was entirely absorbed into the much heavier, universally condemned charge of piracy.
Wow, that's intense.
It is a massive flex of state power. It demonstrates that the Philippines prioritizes the security of its maritime borders above almost everything else. If you hijack even a small fishing boat in Philippine waters, the state does not view you merely as a thug committing a crime against a few fishermen. It views you as a pirate, an enemy of all mankind, actively threatening the sovereign security of the archipelagic nation itself.
Okay, let's pause and synthesize this. We've established a massive invisible dome of jurisdiction over the archipelago. If you step inside the dome, the RPC applies. If you say outside the dome, you're supposedly free.
Supposedly.
Right, because reading through the white papers on jurisdictional reach, it becomes clear that this dome is not perfectly solid. There are legal tentacles that can reach out of it and drag you back.
You are referring to the concept of extraterritoriality. While the territoriality principle is the general rule, Article 2 of the Revised Penal Code explicitly carves out 5 specific, highly strategic exceptions where Philippine penal law will actually follow you beyond its physical borders.
But why would a sovereign nation care what happens outside its borders? Doesn't that violate the sovereignty of other countries?
It is entirely about self-preservation. The state extends its reach to protect its most vital existential interests. For instance, the law applies if someone commits an offense on a Philippine-registered ship or airship out in the international high seas. The vessel is considered a floating extension of the territory.
Oh, interesting.
It also applies if public officers commit crimes in the exercise of their official functions while stationed abroad.
So if a Philippine diplomat stationed at an embassy in Europe is caught embezzling government funds or accepting bribes to issue visas, the Philippine government isn't going to let the European authorities handle it.
Exactly. The crime directly attacks the integrity of the Philippine government. We punish them locally to protect the sanctity of our own institutions, regardless of where the physical act occurred.
But the exception that I find most fascinating because of how it ties into modern globalization is the economic protection doctrine. If I am sitting in a subterranean basement in London and I have never set foot in Manila in my entire life, but I am operating a massive printing press forging Philippine currency, the Philippine government can charge me under the RPC.
They can and they will. Forging currency abroad is punished extraterritorially because fiat currency relies entirely on global faith. If you flood the international market with counterfeit pesos, you devalue the currency, you induce inflation, and you threaten the nation's economic stability and national credit.
Right, so it's practically an attack on the country itself.
Yes, an attack on the currency is an attack on the state's survival. Therefore, its penal reach must extend globally to neutralize that threat.
But let's look at the mechanics of this. You can charge the guy in the London basement on paper, but the Philippine National Police cannot just fly to the UK, kick his door down, and drag him onto a flight to Manila.
No, they definitely can't do that.
They have to ask the British government to hand him over. They have to use extradition. And our white paper details how mechanically strict and frustrating this process can be for prosecutors.
Extradition is the mechanism that prevents international law from descending into chaos. It is governed by intense bilateral treaties, and it acts as a massive restrictive filter on the state's extraterritorial ambitions. You cannot simply demand a fugitive. You must navigate two golden rules of international extradition.
Let's walk through them. First is the rule of specialty.
The rule of specialty is a guarantee of good faith between nations. It mandates that if a host country agrees to hand a fugitive over to the requesting state, say, the Philippines can only try that individual for the specific exact crimes listed in the approved extradition request.
So you can't extradite someone on a minor charge of tax evasion just to get them on your soil and then suddenly surprise them with a murder charge the moment they land at the airport.
Precisely. If you do that, the host country will never trust your extradition requests again. The requesting state is bound by the specific parameters of the surrender.
And the second rule is even trickier, the dual criminality rule.
Yes, the dual criminality rule requires that the act the fugitive is accused of must be legally defined and codified as a crime in both the requesting country and the host country.
And this exact rule tripped up the Philippine government in a highly publicized 2017 case, HKV Munoz. What happened here?
Munoz perfectly illustrates the friction of dual criminality. The government of Hong Kong wanted to extradite an individual who had fled to the Philippines. Hong Kong wanted him to face charges for a crime known in their system as private sector bribery.
Meaning bribery that doesn't involve a government official, like a corporate executive taking a kickback to award a contract to a specific supplier.
Exactly. Corporate corruption. However, when the extradition request hit the desks in Manila, the Philippine legal system hit a wall. At the time of the request, while the Philippines had extensive laws against bribing public officials, private sector bribery was not specifically codified as a distinct criminal offense under the Revised Penal Code or any special penal law.
The legal concept simply didn't exist in our books.
Because the identity of the elements was missing, the dual criminality rule failed. The Philippine Supreme Court ruled that the Philippines could not act as a jurisdictional surrogate to enforce a foreign law that had no domestic equivalent. The extradition request was denied, and the individual was protected by the incompatibility of the two legal systems.
It's a fascinating look at how the law is constrained by international borders and definitions. But what about the borders of time? We have the physical borders, but we also have temporal borders.
Temporal borders, I like that.
Well, every democracy has a constitutional ban on ex post facto laws. The fundamental logic is prospectivity. You cannot be punished today for doing something that was totally legal yesterday.
That is the principle of prospectivity, encapsulated in the Latin maxim nullum crimen, nulla poena sine lege. There is no crime where there is no law punishing it. The machinery of the law can only move forward into the future. It gives citizens fair warning of what is prohibited.
But when you read Article 22 of the RPC, it introduces a massive plot twist to the concept of time, the favorable exception.
Article 22 is one of the most uniquely compassionate provisions in the code. It states that if the legislature passes a new penal law, and that new law is more lenient, or it reduces the penalty for an offense, or it decriminalizes an act entirely, that new law abandons prospectivity. It applies retroactively to past crimes. It essentially travels backward in time to benefit the accused.
So if I am serving a 10-year sentence for a crime, and Congress suddenly passes a law saying the maximum penalty for that crime is now only 5 years, my sentence is magically reduced to 5 years.
Yes. The state applies the new favorable standard to you immediately. We see this dynamic play out vividly in modern jurisprudence. Look at the 2024 case, Peña v. People. The government enacted the Community Service Act, recognizing that packing nonviolent offenders into overcrowded jails for minor infractions was counterproductive. The act allows courts to sentence offenders to community service instead of jail time for light offenses.
And because this new alternative is clearly more favorable to the accused than rotting in a cell, the Supreme Court ruled in Peña that it must be applied retroactively. They looked backward to help people who had committed crimes long before the Community Service Act was even a draft bill in Congress.
We see the exact same retroactive grace applied in the Gintu case regarding the Good Conduct Time Allowance, or GCTA. The GCTA law expanded the formula for reducing prison sentences based on good behavior. The court affirmed that this favorable computation must reach back and apply to prisoners convicted prior to the law's passage. If the evolution of the law helps you, it reaches back to pull you forward.
But this is the law. There is always a catch, right? The state doesn't just hand out time-traveling grace to everyone.
No, it doesn't. The catch is found in the final clause of Article 22. This retroactive benevolence is entirely, absolutely denied if the offender is a habitual criminal.
Define habitual criminal in this context.
It refers to someone who has repeatedly been convicted of specific crimes like serious physical injuries, robbery, theft, or estafa within a specified time frame. If you are a repeat habitual offender, the law views you as having rejected the social contract multiple times. You have proven that leniency does not work on you.
So you don't get the break.
Exactly. Therefore, the law refuses to look backward to help you. You are permanently stuck with the harsher original penalty that existed when you committed your crime.
That makes logical sense. But before we move on, I want to briefly touch on a case mentioned in our syllabus regarding the ex post facto ban, the Trelanes case. The court ruled here that a government cannot unilaterally revoke an amnesty that was validly granted in the past because doing so would effectively reinstate a criminal charge retroactively, violating the ex post facto ban. And to you listening, I want to be crystal clear. We are highlighting this case purely to illustrate the absolute mechanical strictness of the ban on retroactive punishment. We are strictly analyzing the legal architecture here, entirely divorced from any political figures or commentary. It's just a perfect, high-profile example of how the boundaries of time operate in constitutional law.
It is a perfect structural example, yes.
But wait, let me play devil's advocate here and push back on this entire concept of Article 22.
Go for it.
We started this whole deep dive by establishing that the RPC is built on the classical theory, the vending machine. Libre albedrio. You made the free choice to do evil, so the state demands a strict, mathematically proportionate retribution. You do the crime, you do the exact time.
Right, that's the foundation.
Doesn't this favorable exception retroactively lowering penalties because societal standards change totally undermine that classical foundation? Doesn't this mean the state is basically admitting that its old vending machine was calibrated wrong, that its old penalty was too harsh, and that retribution is actually relative?
That is a phenomenal observation, and it cuts to the heart of the code's internal contradiction. You are absolutely right. The favorable exception in Article 22 is, structurally speaking, a massive positivist loophole carved directly into the classical retributive framework of the code.
It breaks the math of retribution.
It does. It is the state openly acknowledging that justice isn't just about cold, static retribution. It acknowledges that human understanding evolves, societal standards of cruelty evolve, and the law must evolve with them. It shows that the penal code isn't a dead monument to 1932 morality. It's a living architecture that can and must bend toward mercy when the legislature deems it appropriate, provided, of course, you aren't a habitual criminal who has forfeited that right to mercy.
Okay, so we've mapped out the physical borders of the archipelago, the extraterritorial tentacles, and the temporal borders of retroactive lenity. Now, we are going to zoom all the way in.
Getting microscopic.
Yes, we are going to look inside the microscopic space of the human mind, because ultimately, we need to know what actually transforms a physical action into a punishable crime. Like, if we are walking down the sidewalk and I bump into you and you drop your phone and it shatters, that's just an unfortunate accident.
Definitely.
But if I look at you, wind up and violently shove you so that you drop your phone, that's a crime. The physical result of broken phone is exactly the same. So what is the difference?
The difference is entirely internal. It is the anatomy of the offense, which the RPC categorizes into 3 distinct buckets: dolo, culpa, and malo prohibita. Let's start with the most common, dolo, which governs intentional felonies.
Okay, dolo.
And right away, our sources clarify a major historical translation error that has confused law students for decades. The English version of the RPC often translates the Spanish word dolo as deceit. But legally speaking, that is an improper and limiting translation. Dolo, in the context of criminal law, truly means malice.
Malice. An evil intent, a deliberate desire to cause harm.
Yes. And for dolo, for malice to exist in the eyes of the court, the prosecution cannot just point to a bad result.
Yeah.
They must prove the existence of a trinity of elements within the offender's mind at the time of the act: freedom, intelligence, and intent.
Let's break those down. Freedom we touched on earlier. It means you are acting without overpowering physical compulsion or uncontrollable fear. Nobody is holding a gun to your head, forcing you to act.
Right.
Intelligence means you have the cognitive mental capacity to understand the consequences of the act, which is why infants or those with severe mental incapacities, as we discussed in Ruiz y Serrano, lack intelligence under the law.
And the third, the most heavily litigated element, is intent. Intent means you are deliberately, consciously using a particular means to achieve a prohibited, felonious result.
Now, I need to pause and clarify something that is constantly conflated in pop culture and true crime shows. People constantly confuse intent with motive. They sound like the same thing. They both deal with why someone did something, but legally, they're galaxies apart, aren't they?
They are entirely different concepts, and confusing them can derail a trial. Let's separate them. Intent is the deliberate use of a particular means to achieve a specific physical result. If I point a loaded gun at your chest and pull the trigger, my intent is to shoot you and end your life.
Okay, that's clear.
Motive, on the other hand, is the psychological, emotional driver behind the intent. It is the invisible why. Why do I want to end your life? Maybe I want to inherit your money. Maybe I am consumed by romantic jealousy. Maybe I am seeking revenge for a past slight.
And here is the reality check that always shocks people. Legally speaking, your motive, the deep psychological reason you committed the crime, is completely irrelevant to establishing your guilt.
Totally irrelevant.
Let's say I break into a bakery and steal a loaf of bread. My motive is that my children are starving and I'm desperate to feed them. The guy next to me breaks into the bakery and steals a cash register because he wants to buy luxury sneakers. Our motives are morally miles apart.
Absolutely.
But under dolo, the judge looks at both of us and says, did you have the freedom, intelligence, and intent to take property that didn't belong to you?
The answer for both of you is yes. You both have the intent to commit theft. Therefore, you are both equally guilty under the classical framework of dolo. The purity of your motive does not erase the malice of your intent to steal.
So does motive ever actually matter in a courtroom, or is it just something prosecutors talk about to give the jury a good story?
Motive only becomes legally essential in one highly specific scenario: when the identity of the perpetrator is a mystery. If a man is found murdered in an alley, and there are no witnesses, no cameras, and the evidence is purely circumstantial, the court does not know who possessed the intent.
Because they don't know who did it.
Exactly. In that vacuum, the investigators and the court must look at motive. They have to ask who stood to benefit, who was jealous, who had a reason to kill this man. Motive is used to connect a suspect to the intent, but if the crime is caught on high-definition video and the intent and identity are absolute, motive is legally discarded. It might be used later to plead for mercy during sentencing, but it has no bearing on the verdict of guilt.
Okay, so dolo requires a deliberate, malicious intent to cause harm. But what if you genuinely meant no harm? What if there's zero malice in your heart, but your actions result in a tragedy? You can still be sent to prison, right?
You absolutely can. That brings us to the second bucket, culpa, or culpable felonies. In culpa, the state acknowledges that you meant no harm. There is no evil intent, no malice whatsoever. However, you are still punished because of fault. The legal mechanics of culpa are tricky. The initial act you performed was entirely voluntary, but the disastrous, harmful result was completely unintended.
So how does the law measure fault if there is no malice? How do they know you crossed a criminal line?
The law measures fault through two specific manifestations: imprudence and negligence. Imprudence is defined as a deficiency of action. You took an action that you shouldn't have taken. You lack skill or precaution. Reckless driving is the classic example of imprudence. You voluntarily pressed the gas pedal, but you lacked the precaution to realize you were going too fast for the conditions.
And negligence.
Negligence is a deficiency of perception. You failed to take an action that you should have taken. You failed to foresee a danger that a reasonable person would have seen.
Can you give an example?
A classic example is a construction worker who digs a 10-foot hole on a public sidewalk and simply walks away without putting up warning signs or barriers. A pedestrian falls in and breaks their neck.
Right.
The worker didn't intend to hurt anyone, but their failure to perceive the danger and act on it constitutes criminal negligence.
The syllabus cites a 2016 case, Senate v. People, which perfectly illustrates the mechanics of culpa. Paint the scene for us.
Senate involves a horrifying vehicular accident. The accused was driving a vehicle at a high rate of speed. Coming up behind a slower vehicle, he made the aggressive choice to overtake the car, but he didn't use the passing lane. He swerved and overtook the vehicle on the right shoulder of the road.
Oh, that's incredibly dangerous.
Yes. And in doing so, he lost control, causing a catastrophic collision. Now, when you analyze his mind under dolo, did he wake up with malice? Did he intend to crash and cause injuries? No.
But the court still convicted him.
They did. The court ruled that his voluntary action choosing to speed and pass on the right shoulder represented a flagrant, inexcusable failure of precaution. He possessed freedom and intelligence, but he completely lacked foresight. The court determined that his reckless imprudence transformed the completely legal, voluntary act of driving into a culpable criminal offense.
So we have dolo, where you act with malice, and culpa, where you act with catastrophic negligence. But our sources introduce a third category that feels like the ultimate legal wild card.
Mala prohibited.
Yes, mala prohibita. It breaks the rules of both dolo and culpa. These are crimes punished under special laws outside the RPC, things like bouncing a check, possessing an unlicensed firearm, or violating a city ordinance.
Yeah.
And the defining feature of mala prohibita is that intent and negligence don't matter at all.
That is the terrifying power of mala prohibita. These are statutory offenses. The acts are illegal simply and purely because the legislature passed a law saying they are illegal. They are not necessarily inherently evil or malicious acts. Because they are mere statutory prohibitions, the prosecution does not need to prove dolo.
So specific criminal intent is completely immaterial.
Completely. Furthermore, good faith, meaning you genuinely didn't know you were breaking the law, is not a valid defense.
So what is the mental requirement? If they don't need to prove intent or negligence, what do they need to prove?
The only mental requirement for a mala prohibita offense is volition.
Volition, meaning you were awake and you consciously chose to perform the physical act. You weren't sleepwalking and someone wasn't physically forcing your hand.
Exactly. Let's look at the bouncing checks law. If you write a check, hand it to someone, and that check bounces because of insufficient funds, the only question the court asks is, did you voluntarily sign and issue that check?
And if you did?
If the answer is yes, you are criminally liable. It does not matter if you were acting in total good faith. It doesn't matter if you genuinely believed a bank transfer was going to clear in time to cover the check. Your lack of malicious intent is irrelevant. The act of issuing the bad check is prohibited. You did it voluntarily, therefore you are guilty.
It's incredibly strict. But there's a massive nuance here that the white papers highlight, and I think this is crucial for anyone trying to navigate the system. Just because a crime is punished under a special law outside the RPC, it doesn't automatically mean the court will treat it as mala prohibita.
Right, the court isn't just a machine.
The Supreme Court refuses to be a blind robot reading labels. And the prime example of this is the Garcia case.
The Garcia case is vital for understanding the true architecture of criminal categorization. The accused in this case was charged with election tampering under the Philippine Electoral Reforms Law. Now, the Electoral Reforms Law is a special statute, distinct from the Revised Penal Code.
Okay.
So following the basic rule we just discussed, you would naturally assume, it's a special law, therefore the crime is mala prohibita. Intent doesn't matter. Did you physically tamper with the ballots? Yes. Guilty.
It should be an open and shut case of volition.
But the Supreme Court hit the brakes. They said, no, we cannot blindly apply the mala prohibita standard here. The court looked past the statutory label and examined the very nature, the soul, of the act itself.
And what did they find?
They reasoned that tampering with an election, subverting the democratic will of the people, and stealing votes is an act so inherently immoral, so deeply corrupt and malicious, that it crosses the line. It ceases to be merely prohibited by statute. It becomes mala in se, an act that is fundamentally wrong in and of itself.
And because the court reclassified the soul of the crime as mala in se, the rules changed.
Completely. Because they recognized the inherent malice of the act, the Supreme Court ruled that the prosecution was required to prove specific criminal intent, dolo. They had to prove that the tampering was done maliciously and intentionally, not just accidentally or through a clerical error. The overarching lesson from Garcia is that the inherent nature of the act always dictates the standard of proof, regardless of where the law is written down.
That is fascinating. The court looks past the packaging and weighs the moral gravity of the action. Okay, so we have dissected the mind of the offender. The law requires either malicious intent, reckless negligence, or mere statutory volition. But human beings are chaotic, and the universe is unpredictable.
Very true.
What happens when reality violently intercepts your intent? What happens when you pull the trigger or throw the punch, but the universe intervenes and the final result is something totally, completely unexpected?
You are stepping into the chaotic realm of proximate cause, which is governed by Article 4 of the RPC. And to understand how the law handles this chaos, you have to internalize one overarching foundational legal maxim. He who is the cause of the cause is the cause of the evil caused.
He who is the cause of the cause is the cause of the evil caused. That is a mouthful. In practical terms, what does that actually mean for the guy who threw the punch?
It means that under Article 4, once you generate a felonious intent and translate it into an overt action, you become legally tethered to the outcome. You are held criminally liable for all the direct, natural, and logical consequences of your felonious act, even if the final tragic result is completely different from what you originally intended.
Okay, our sources break this chaotic reality down into 3 specific variants of unintended consequences. Let's run through them to see how this tethering actually works. The first variant is error in personae.
This is a mistaken identity. Let's say you have formed the malicious intent to murder your rival, John. You study his habits, you wait in the dark outside his house. A figure walks through the door wearing John's coat. You fire the gun, killing the person instantly.
But it wasn't John.
Exactly. When you step into the light, you realize John wasn't wearing his coat that night. You just murdered his brother, Peter? You had absolutely no motive to kill Peter. You bore Peter no malice.
But the law doesn't care.
The law does not care. Under error in personae, you are fully liable for the intentional murder of Peter. Your initial felonious intent to kill a human being carries over and attaches to the actual victim. The mistaken identity does not sever the proximate cause.
The second variant is praeter intentionem.
In this scenario, the end result is vastly worse than you ever intended. Imagine you are in an argument and you decide you just want to teach the guy a lesson. You intend to give him a black eye, so you punch him squarely in the face.
Okay, simple assault.
But the force of the punch causes him to stumble backward. He trips over the curb, cracks the back of his skull on the concrete pavement, and dies of a brain hemorrhage.
You never intended to kill him. Your intent was localized purely to causing a minor physical injury.
True. But under praeter intentionem, you are criminally liable for homicide. The court will rule that his death, while unintended, was the direct, natural, and logical consequence of your initial felonious assault. The chain of causality is unbroken.
And the third variant, which frankly has the coolest Latin name in the entire code, aberratio ictus. Mistake in the blow.
Yes, aberratio ictus.
The syllabus brings up the Illigan case to illustrate this, and it is a perfect example of chaos theory in criminal law. Imagine a scene. I am furious at you. You are driving down the street. I pick up a massive heavy rock and I hurl it at your car. My entire intent is simply to smash your windshield and cause property damage.
But your aim is terrible. The rock deflects off the hood of the moving car. It ricochets at a high velocity into a crowded sidewalk, and it strikes a completely innocent bystander in the head, killing them instantly. You didn't even know that bystander was standing there.
Under the vending machine theory of dolo, I didn't have the intent to kill a human being. I had the intent to break glass. So am I only charged with malicious mischief?
Absolutely not. Under aberratio ictus, as affirmed by the Supreme Court in the Illigan case, you are fully, criminally liable for the death of that bystander. The legal reasoning is rooted in physics. You intentionally generated a violent felonious force by hurling that rock. That felonious force had a direct, unbroken causal link to the impact on the bystander's skull. Your lack of specific intent to kill that specific person does not shield you from the horrific consequences of the unguided missile you unleashed on society.
So, proximate cause is basically like tipping the first domino in a massive, complex chain. Even if a gust of wind blows or someone sneezes and knocks over the last 3 dominoes prematurely, the law looks back at the chain and says, you are the one who tipped the first piece. You set this whole chaotic, destructive sequence in motion. You own the result.
That is a highly accurate way to visualize it. But it also raises the most common, desperate defense argument in these types of cases. What if there is an intervening force?
Like someone else jumping in.
Right. What if you tip the first domino, but halfway through the chain falling, someone else walks into the room and kicks the entire table over? Who owns the final result then?
Right. Let's test this. Let's say I stab someone in the shoulder during a fight. It's a bad wound, but it's not fatal. The victim goes to the hospital. But the emergency room doctor is completely incompetent, or maybe they are intoxicated, and they violently botch the surgery, causing the victim to bleed out and die on the operating table.
Can I stand before the judge and say, hey, don't look at me for murder. I just caused a flesh wound. The doctor is the one who killed him.
It is a logical defense strategy, but based on established jurisprudence, particularly the De Ocampo case, you will almost certainly lose. In De Ocampo, a teacher was disciplining students and violently banged their heads together. One student suffered severe trauma and died days later. The defense argued vehemently that it was the unskillful, negligent medical treatment at the local clinic that ultimately caused the death, not the initial impact.
And the Supreme Court rejected that completely. The court ruled that subsequent medical neglect or even unskillful treatment by a doctor does not sever the proximate causal link back to the attacker. The court applies a but-for logic. But for your felonious act, the victim would never have been subjected to the unskillful doctor in the first place. You place them in the zone of danger. Therefore, your initial strike remains the proximate cause of their ultimate demise.
That is a heavy burden to bear. So is there any intervening force that can break the chain of proximate cause and save you from the final result?
Yes, but the standard is incredibly high. To break the chain, the intervening force must be an efficient intervening cause. It must be a force that is completely distinct, absolutely foreign, and entirely independent of your initial act.
Give me an example of an efficient intervening cause.
To use your stabbing scenario.
Yeah.
You stab someone on the shoulder, they go to the hospital. While they're lying in the hospital bed recovering from the non-fatal wound, the hospital is struck by a meteor or a catastrophic earthquake collapses the building, killing everyone inside.
Okay, that is pretty extreme.
Yes. And in that absurd act of God scenario, the chain is definitively broken. The earthquake is an efficient intervening cause that entirely supersedes your initial act. You would be charged with physical injuries for the stabbing, but you would not be charged with homicide for the building collapse.
Which brings us circling all the way back to the wild hypothetical we started this deep dive with, the impossible crime.
Yes, Article 4, Paragraph 2.
Let's review the take. You sneak into the room, you fire a bullet into the guy in the bed, but you find out he died of a heart attack an hour ago. Or, taking another classic law school hypothetical, you want to poison your boss. You sneak into the break room and pour a massive spoonful of white powder into his coffee, genuinely believing the powder is deadly arsenic. But you mixed up the jars and you actually just poured powdered sugar into his coffee. In both cases, the intended result, murder, is physically and factually impossible.
These are the textbook definitions of an impossible crime. And to be convicted and punished for this under the Philippine system, the court must identify 3 specific, rigid elements.
What are they?
First, the act you performed would normally constitute a crime against persons or property. Shooting a gun or poisoning a drink clearly fits. Second, you performed the act with evil intent, with dolo. You wanted the person dead. Third, and this is the crucial part, the accomplishment of the crime was prevented by inherent impossibility, like trying to murder a corpse, or by the employment of an inadequate means like trying to induce a lethal overdose using sugar.
But this is where the logic of the law feels so counterintuitive to the average person. We just spent all this time talking about proximate cause and how you are punished for the damage you cause. In an impossible crime, you cause 0 damage. The dead guy is still dead. The boss just had a slightly sweeter cup of coffee. Why on earth does the state spend resources punishing you for failing so spectacularly? You didn't hurt anyone.
It is counterintuitive if you only look at the physical result. But you have to remember the positivist influence we discussed in Section 1. In an impossible crime, the state isn't punishing the result. It is punishing the felonious spirit.
Explain that. What is the felonious spirit?
By taking the calculated steps to creep into that room with a loaded gun, or by deliberately pouring what you thought was poison into a cup, you have demonstrated a clear, undeniable criminal propensity. You have shown the state that you have the malice to kill, and you possess the absolute willingness to act on that malice. You are a profound danger to society. The state punishes the impossible crime proactively to suppress that dangerous tendency and remove you from the streets before you figure out how to find real arsenic.
It's almost like the law is punishing your bad karma, or punishing the darkness in your soul, rather than the physical reality of the universe.
That's a very poetic way to frame it.
Okay, so we've established that a crime isn't just a static snapshot, it's a moving picture. From the moment you first conceive the dark thought, to the preparations, to the execution, to the final result. And the law, being a system of precise rules, has to decide at what exact frame in that moving picture you officially become a criminal.
We are now transitioning into the journey of a crime, which is mechanically mapped out in Article 6 of the RPC. Article 6 defines the stages of execution. And the very first inviolable rule of this journey is that internal thoughts are never punished. You can sit in your living room and meticulously fantasize about robbing a bank all day long. You can write the plan down in a diary. As long as it remains an internal, unacted upon thought, the state cannot touch you.
But what if I move from thought to preparation? What if I decide I'm actually going to do it? I go to the hardware store, I buy a black ski mask, a heavy crowbar, and a can of gasoline. I put them in the trunk of my car. Can the police arrest me for attempted robbery just based on my shopping list?
Generally speaking, no. Preparatory acts are also not punished. Buying a ski mask or gasoline is in and of itself a completely neutral legal act. The law does not want to punish people for running errands. However, because the state is always focused on self-preservation, there are high-yield exceptions where specific statutes elevate a preparatory act into a crime itself.
Give me an example of a criminal preparatory act.
The primary example found in the code is the possession of picklocks, or similar tools under Article 304. If the police find you possessing the specialized tools of a burglar, and the circumstances indicate you have the intent to use them, you can be punished. You haven't approached a door yet, you haven't scratched a lock, but the mere possession of those specific tools with intent is a crime. But outside of those very narrow specific exceptions, the line into general criminal liability is not crossed until you perform the overt act.
The overt act. The moment your internal malice breaches into physical reality, and once you cross that line, you enter the rigid matrix of Article 6. Our primer breaks this journey down into two crucial, distinct phases, the subjective phase and the objective phase. Understanding the boundary between these two phases is probably the most crucial mechanical distinction in the entire penal code. Let's start with the subjective phase. Walk us through it.
The subjective phase covers the timeline where you are actively physically committing the overt acts of the crime, but you still retain complete physical control over your actions and the outcome. Imagine an arsonist. You have poured the gasoline around the foundation of the house. You are holding the matchbox. You are in the subjective phase.
And because I'm still holding the matchbox, because I still have control, the law grants me a sort of legal superpower, spontaneous desistance.
Exactly. The law wants to incentivize you to walk away from the brink. If you are deeply in the subjective phase and you suddenly feel a pang of remorse, or perhaps you get terrified of going to prison and you stop the crime willingly, entirely on your own volition, the law rewards you. This is spontaneous desistance. You are absolved of criminal liability for the attempted felony. You might be charged with trespassing, but you will not be charged with attempted arson. The state says, "Thank you for stopping. Go home."
But what if my desistance isn't voluntary? What if I am pouring the gasoline, I'm reaching for the matches, but a police officer jumps out of the bushes and violently tackles me to the ground, slapping handcuffs on me?
Then your desistance was not spontaneous. It was caused by an external foreign force. At the exact moment the officer tackles you, your journey is frozen in the subjective phase. You have committed an attempted felony. You commence the overt acts, but you did not perform all the acts of execution due to an outside cause independent of your will.
Okay, so that is the subjective phase, control. But what happens when I strike the match? What is the objective phase?
The objective phase begins the exact millisecond. You have performed every single act of execution necessary to complete the crime. You have poured the gasoline, you have struck the match, and you have dropped the lit match onto the puddle of fuel. Or, in a shooting, you have aimed the gun and fired the last bullet in the chamber at your target's chest. At this point, you have done everything you possibly can. The rest is up to physics. Control has entirely left your hands. The outcome now depends on the wind, the aim, fate, or the intervention of third parties.
And because I have surrendered control to the universe, I lose my superpower. Spontaneous desistance is completely off the table. I can't fire a bullet at someone's chest, watch it flying through the air and yell, "Wait, I changed my mind, I desist."
Exactly. You have crossed the point of no return. The law no longer cares about your remorse. Now we just wait for the result. If the bullet hits the victim in the heart, but they miraculously survive, perhaps because a brilliantly skilled trauma surgeon operates on them for 10 grueling hours, the crime failed to produce death for reasons completely independent of your will. This is categorized as a frustrated felony.
And if the surgeon fails and the victim dies, or if the dropped match successfully burns the house to the ground, it is consummated. All the physical elements defined by the law are present. Attempted, frustrated, consummated. It sounds like a very clean, logical progression. But here is where the application gets incredibly tricky. The primer refers to this stage analysis as the homicide crucible, because figuring out the exact moment a crime becomes consummated looks totally different depending on the specific crime you are committing. The definition of consummation is a chameleon.
It is highly variable, and it depends entirely on the legal definition of the specific crime. Let's look at arson, as we've been discussing. To consummate the crime of arson, you do not need to watch the entire house burn to a pile of ash. If even a slight microscopic portion of the building catches fire, just a singed wall panel or a scorched floorboard. The Supreme Court rules that the crime of arson is fully 100% consummated. The danger was fully realized.
What about theft? This one always confuses people. If I steal your gold watch from your desk, but the police catch me in the hallway before I can leave the building or before I can pawn it, is that frustrated theft? Like I have the watch, but I haven't successfully escaped with it yet.
It is a logical question, but Philippine jurisprudence has effectively squeezed out the frustrated stage for the crime of theft. The Supreme Court has ruled that the exact moment you take unlawful physical possession of the item and gain final control over it, the moment the watch is in your pocket and you take a step, the theft is fully consummated. There is practically no window for frustrated theft. The violation of property rights is complete upon possession.
But the most profound and frankly the most debated legal fiction in this entire area of stages surrounds the crime of rape. Our sources highlight a landmark 1999 Supreme Court decision, People v. Quinola. This ruling completely rewired how the law views the physical stages of execution for sexual assault. Walk us through the holding.
Quinola, which was later reinforced by the overarching logic of the anti-rape law of 1997, cemented a vital legal fiction into the jurisprudence. The court declared that frustrated rape simply does not exist in Philippine law. It is legally inconceivable.
Why? If we look at the strict physics of the subjective and objective phases we just spent 10 minutes discussing, if someone begins an assault but is physically interrupted by a bystander before full penetration occurs, objectively speaking, they have not performed all acts of execution. So why did the Supreme Court erase that middle stage?
They erased it because of the immense overriding value the state places on the integrity, dignity, and psychological sanctity of the victim. The courts determined that in the crime of rape, the core injury is not just physical, it is a profound violation of human dignity. Therefore, the Supreme Court established that the crime is fully consummated upon the slightest contact of the male organ with the labia. It emphatically does not require full penetration or completion of the act in a biological sense. By eliminating the frustrated stage, the law ensures that the very second the physical violation begins, the crime is viewed as complete, absolute, and consummated in the eyes of justice.
I understand the moral imperative behind that ruling. It's a powerful statement by the court. It declares that the injury to the victim's dignity doesn't wait for biological completion. The devastation happens at the first moment of violation. But I have to push back on this from a purely architectural standpoint. We just outlined this incredibly precise logical matrix of subjective versus objective phases: attempted, frustrated, consummated. If the court can just look at a specific crime and say, we find this crime so abhorrent that we are going to erase the middle stage, aren't they breaking the physics of their own penal code? Aren't they redefining time and space just to achieve a moral victory? Isn't that dangerous judicial overreach?
You are tapping into the exact critique raised by strict constructionist legal scholars when Quinola was decided. They argued precisely what you were arguing, that the court was abandoning legal mechanics for emotional resonance. But the majority opinion and subsequent legislation countered that the mechanics of the law must serve the reality of the human experience, not the other way around. The court argued that waiting for full penetration to declare the crime consummated applied an antiquated, purely biological metric to an act that is fundamentally about power and violation. They didn't break the physics of the code, they recalibrated the definition of the injury itself. Once the injury to dignity occurs, the crime is complete. It is a positivist triumph over classical rigidity.
It is a fascinating debate between the rigid letter of the law and the evolving spirit of justice. Okay, let's unpack this next massive segment. Everything we have discussed so far, from intent to proximate cause to the stages of execution, has focused on the timeline of a solo offender, the lone wolf. But crimes in the real world are rarely that clean. They are messy, chaotic enterprises. They involve multiple people, lookouts, getaway drivers, financiers, masterminds. How does the RPC handle the mathematics of group crimes?
This brings us to the terrifying mathematics of guilt. Conspiracy, which is governed by Article 8 of the RPC. The foundational rule of conspiracy is one of the most famous, devastating maxims in all of criminal law. The act of one is the act of all.
The act of one is the act of all. Let's translate that. If 4 of us sit down in a diner and plan to rob a bank, I am terrified of guns. I say, I will not go inside. I will just be the guy sitting in the running getaway car outside. You go inside with the gun, the teller panics, and you end up shooting and killing the security guard. When the police catch us, I'm on the hook for murder, even though I was sitting in the car listening to the radio.
If the prosecution successfully proves that a conspiracy existed between the 4 of you, yes, you share absolute, equal, undivided liability for the ultimate result of that conspiracy. The law erases the distinction between the mastermind, the triggerman, and the getaway driver. The lookout sitting in the car goes to prison for the exact same amount of time, the exact same charge of murder as the person who pulled the trigger.
That is a brutally wide net. But proving a conspiracy isn't always easy, and the consequences are so severe that courts have to be careful. And our sources show that the Supreme Court has actually been making it significantly harder for prosecutors to prove conspiracy recently. They are actively refining the rules to protect peripheral people from being swept up in mass charges. We see this vividly in the 2025 Ampachuan case and the 2024 Morales case. Walk us through this modern refinement.
These are crucial, life-saving modern refinements for anyone caught in the periphery of a crime. In the past, prosecutors would often cast a massive net. They might try to argue that if you were simply present in the room where a crime was being discussed and you didn't vocally object, you were part of the conspiracy. But in the 2025 Ampachuan ruling, the Supreme Court definitively shut that door. They ruled that mere presence at a meeting or even silent approval of a plan is absolutely insufficient to establish conspiracy.
You can't just nod your head or sit quietly in the corner.
Right. The court demands action. And in the Morales case, they address the nightmare of bureaucratic crimes, like mass malversation of public funds. Prosecutors love to charge entire departments. But the court ruled in Morales that merely signing an official document like a routine payroll sheet or a requisition form in the normal, everyday course of your clerical duties does not magically make you a conspirator, just because a corrupt superior later used that document to steal millions.
So what does it take? If silence and routine signatures aren't enough, what is the new standard?
The state must prove an overt physical act done in actual conscious furtherance of the shared corrupt design. You must take a positive, deliberate step to help the crime succeed. You have to actively advance the plot.
But wait, the 2024 Breguet case shows a flip side to this strict requirement. Conspiracy doesn't always look like a bunch of criminal masterminds sitting around a dimly lit table drafting a 10-point plan. Sometimes it's chaotic.
That is the doctrine of implied conspiracy, and Breguet is the perfect modern illustration. The court reminded us that you do not need a secret meeting, a text message thread, or a formal verbal agreement to be labeled a conspirator. Let's say a spontaneous brawl breaks out outside a bar. If 2 people who have never met before suddenly start coordinating their physical attacks on a single victim, one person pins the victim's arms behind their back while the other person repeatedly punches them in the face, the court does not need a signed contract.
The coordination is the contract.
Exactly. The court can legally infer a common, shared design from their joint concerted physical actions in the heat of the moment. The conspiracy is implied by how seamlessly they acted together to cause harm.
So the law is constantly weighing this chaotic evidence, trying to figure out who is truly guilty, who was just standing there, and who is actively participating. And that monumental task of weighing evidence brings us to the final, and perhaps most important, piece of our deep dive: the rules of interpretation. These are the built-in safeguards, the circuit breakers in the system, designed to protect you and me from the awesome, crushing weight of the state.
This is where we zoom out and look at the power dynamic of a criminal trial. Remember the premise of our entire discussion. The state has a terrifying monopoly on violence. When you are accused of a crime, you are facing the unlimited resources of the government. They have the police force, the investigative agencies, the forensic labs, the prosecutors, and the prisons. The individual citizen is inherently, massively at a disadvantage. Therefore, the RPC and the Constitution rely on rigid rules of construction to attempt to level that playing field. The first of these is a fascinating historical quirk: the Spanish text rule.
Right, because as we established at the beginning, the code was originally drafted and debated in 1932.
Yes, and it was drafted primarily in Spanish, based on the old Spanish Penal Code. The English version we use today is a translation, so the Supreme Court has a standing rule. If there is ever a conflict, a nuance, or an ambiguity between the English translation of a law and the original Spanish text, the original Spanish text controls the courtroom. The original intent of the 1932 framers overrides a clunky modern translation.
That is a great piece of legal trivia. But the next rule is far more consequential for the average person facing jail time: the rule of lenity.
The rule of lenity is a fundamental shield against state overreach. It dictates that all penal laws must be strictly construed against the state and liberally construed in favor of the offender. What this means in practice is that if the legislature writes a sloppy, vague statute that can reasonably be interpreted in two different ways, one way sends you to prison for 10 years, the other way sends you to prison for 2 years. The court is legally obligated to choose the interpretation that favors the accused. The state cannot benefit from its own vague drafting.
Which perfectly sets up the ultimate tiebreaker in criminal law, the equipoise rule. The syllabus highlights the Diada case here, and I think this is the most profound concept we've discussed today. What happens when the evidence is perfectly, frustratingly balanced?
In Capistrano Diada v. People, the Supreme Court articulated this concept beautifully. I want you to imagine the literal scales of justice. On the right side, the prosecution places all its evidence pointing toward guilt. On the left side, the defense places all its evidence pointing toward innocence. If those scales are perfectly balanced, if the facts of the case are genuinely susceptible to two equal interpretations, one consistent with guilt and one consistent with innocence, the court's hands are tied. The court must favor acquittal.
The tie goes to the runner. Or in the brutal reality of a criminal trial, the tie goes to the accused.
Exactly. And the reason is the constitutional presumption of innocence. The state bears the ultimate burden of proving guilt beyond a reasonable doubt. If the evidence is an equipoise, if it's a 50-50 split, then reasonable doubt exists by mathematical definition. And in Diada, the court noted a fascinating practical application of this. Objective physical evidence, like the presence of only a single minor injury on a victim's body, will always trump a witness's highly dramatic, exaggerated, emotional story of a massive multi-person mauling. The physical reality cuts through the noise of human testimony and tips the scale.
I want to pause here because this is heavy. How would you frame the philosophical importance of the equipoise rule for someone listening right now who might feel disconnected from all this legal jargon?
I would ask you, the listener, to really close your eyes and think about the sheer overwhelming weight of the state. Think about what it means to have the police knock on your door. Think about the endless funding the government has to prosecute a case against you while you drain your life savings to hire a single defense attorney. The equipoise rule is the ultimate equalizer in a fundamentally unequal fight. What stands out to you about a justice system that intentionally, by structural design, gives the ultimate tiebreaker to the accused? It is a profound, humbling acknowledgement by the state itself. It is the government admitting that its machinery is flawed, and that it's far better for a guilty person to occasionally go free than for one single innocent person to be crushed and locked in a cage by the machinery of the state.
That is a heavy, essential truth. It is the firewall that protects us all. Okay, we have covered an absolutely incredible amount of ground today. Let's pull back and summarize this deep dive. We've essentially traced the living DNA of Philippine criminal law, dissecting Articles 1 through 10 of the Revised Penal Code. We started by exploring how this 1932 architecture is rooted in the classical theory of strict mechanical retribution, the vending machine of justice, built on the absolute presumption of free will. But we also watched in real time as modern Supreme Court rulings actively inject positivist leanings, allowing acute mental health realities and psychotic episodes to override the vending machine in favor of compassion and scientific understanding.
We navigated the strict geographic boundaries of the generality and territoriality principles, exploring the anxiety of warrantless airport searches and the robust assertion of sovereignty through the English rule on the seas. We explored the time-traveling grace of retroactive lenity, where the state bends backward through the borders of time to apply favorable laws to past crimes.
We dissected the mental trinity of malice dolo and how it fundamentally differs from the catastrophic negligence of culpa and the blind statutory volition of mala prohibita. We learned that motive is irrelevant unless the killer is a ghost. We tracked the chaotic physics of proximate cause, learning that you own the chain reaction of the dominoes you tip over. We watched a crime evolve from a mere preparatory thought, crossing the Rubicon from the subjective phase to the objective phase until it reached its chameleon-like consummation. And we saw how the state uses the terrifying net of conspiracy to punish the group, while the courts use the rule of lenity and the equipoise rule to aggressively protect the individual.
It is not a dusty colonial relic. It is a dynamic, constantly evolving, living architecture of human behavior.
And that leaves me with a final, provocative thought for you to mull over as you go about your day. As the Supreme Court continues to issue groundbreaking rulings like Ruiz-Serrano in 2024, rulings that allow severe psychiatric episodes to completely excuse criminal liability without even needing a mountain of prior medical records. Rulings that recognize the fragility of the human mind is this 1932 colonial-era code being completely rewritten through the back door.
It is a very real and very exciting possibility. The friction is producing a new kind of law.
Will there come a day in our lifetimes when the Philippine justice system completely abandons the classical idea of punishment and strict retribution? Will we tear down the vending machine in favor of pure, scientific, positivist rehabilitation? The answer to that profound question isn't written in the dusty statute books of 1932. It's being actively written, passionately argued, and decided every single day down on Padre Forest Street in Manila, right inside the chambers of the Supreme Court.
The real-time software update is ongoing, and we are all subject to the new code.
Keep questioning the architecture of the rules around you. Keep looking at the invisible dome over your head. And the next time you hear a wild hypothetical, like someone going to prison for shooting a man who died of a massive heart attack an hour earlier, you'll know exactly which 1932 law they are talking about and why the state demands to punish the felonious spirit. Thanks for taking this deep dive with us.
Welcome to the debate. You know, when you walk into a beautifully restored 1930s Art Deco building, the experience can be, well, incredibly deceiving.
Right. It looks totally brand new.
Exactly. You see the modern smart lighting, the high-speed elevators, the climate control. Standing in the lobby, you'd swear you're inside a completely modern structure that just, adapts perfectly to the people using it.
Yeah, but if you take a sledgehammer to the drywall, you find the original structural steel. The foundational rivets that were driven in nearly a century ago, they are still the only things keeping the roof from caving in.
Right.
The modern technology is just draped over an ancient skeleton.
And that exact same illusion happens in law. When you look at the Philippine Revised Penal Code today, you see these progressive Supreme Court rulings, modern rehabilitative exceptions. You see a system that seems to adapt to human behavior.
On the surface, anyway.
Right. But underneath it all is that 1932 steel skeleton. So today we are examining the DNA of this legal architecture, specifically Articles 1 through 10 of the Revised Penal Code, or the RPC, which really serves as the bedrock of the Philippine criminal justice system.
It really does.
We're asking a fundamental question. Does this nearly century-old code actually function as a living, modernized framework capable of compassion and rehabilitation? Or does its underlying DNA make it an inescapably rigid, retributive relic that just mechanically punishes the act?
Completely ignoring the human being behind it. It's a profound philosophical divide, and, it's one that affects literally every single person who walks into a Philippine courtroom.
I will argue that modern Supreme Court jurisprudence has successfully transformed the RPC. It has taken this rigid document and turned it into a dynamic, positivist-leaning framework that genuinely adapts to human frailty.
And I will argue that the code's core mechanisms remain stubbornly and frankly fatally anchored in classical mechanical retribution. The modern updates are just an illusion.
Well, to understand this, we have to translate those two philosophies. When the RPC was drafted in the 1930s, it was undisputedly built on the classical theory of criminal law.
Absolutely.
And in plain English, the classical theory views human beings as purely moral creatures with absolute free will. You consciously choose between good and evil. Under that framework, the justice system is effectively a vending machine of retribution.
Right. You put in a crime, out pops a penalty. The math is absolute.
Exactly. You freely chose to do evil, therefore society extracts a mechanically proportionate punishment. But my position is that the law hasn't remained static. It has evolved into a living architecture by integrating the positivist theory.
Which I heavily dispute, but go on.
Well, this theory looks at crime differently. It views it as a social and natural phenomenon. It acknowledges that human beings aren't always acting with absolute free will.
Right.
Sometimes individuals are subdued by mental illness, or extreme poverty, or environmental constraints that are completely beyond their volition. You might see this integration as a facade, but I see it as a genuine evolution.
I absolutely see it as a facade.
But the evidence of this evolution is literally written into modern jurisprudence. Let's look at the 2024 landmark case of Ruiz y Serrano versus People.
Okay.
In this case, you had a defendant who experienced a severe psychotic episode. She was suffering from intense hallucinations at the exact moment a tragedy occurred, resulting in homicide charges. Now, historically, proving insanity was a rigid, nearly impossible hurdle, requiring extensive prior psychiatric records.
Because the classical theory demands punishment.
Right, but the modern Supreme Court admitted her hallucinations as independently relevant statements. They used this to establish a mental state that actually exempted her from criminal liability. That is a profoundly positivist approach.
It's one ruling, though.
But the court didn't act like a vending machine. It recognized human psychological frailty at the exact moment of the offense.
Yeah, that's one case, and it is entirely an exception to the rule.
But it's not the only exception. Look at Article 22. Normally, there is a strict rule against the irretrospectivity of laws, meaning if a new law passes today, you can't use it to punish or help someone who committed a crime yesterday.
Right, the law looks forward.
But Article 22 flips that, creating a favorable exception. In the 2024 Teddy Pena v. People ruling, the court applied the new Community Service Act retroactively.
Ah, the community service case.
Yes, they allowed offenders who had committed light offenses in the past to perform community service instead of just sitting in a jail cell. That isn't mechanical retribution. That proves the state's capacity for grace.
Does it?
I mean, looking backward to say, we can rehabilitate you instead of just locking you up. The RPC is breathing.
I hear you, but those positivist updates are at best cosmetic patches on a profoundly classical structure. To understand the true nature of the RPC, you cannot just look at the Supreme Court throwing a lifeline in a handful of cases.
You have to look at the whole picture.
You have to look at the baseline mechanics of how the code actually assigns liability. And to do that, you have to look at Article 4, Paragraph 2, the impossible crime.
A fascinating piece of the law.
It is. And it exposes exactly what the RPC really cares about. Let's paint a picture here. Imagine a disgruntled employee sneaking into their boss's office at midnight.
Okay.
They intend to murder their boss, so they pour what they believe is deadly arsenic into the boss's coffee pot, and then they flee into the night. But it turns out, in their panic, they grabbed the office sugar packet by mistake.
Oh, wow.
The boss comes in the next morning, drinks the coffee, and is perfectly fine. The coffee is just a little sweeter. Physical harm was objectively impossible.
But under the RPC, that employee is still criminally liable for an impossible crime.
Exactly, but why? Nobody was hurt. Society suffered zero actual damage. They are punished because the state is mechanically punishing the felonious spirit.
The intent.
Right. The RPC isn't looking at the harmless coffee. It's looking at the darkness of the employee's intent. It is demanding retribution for the evil thought alone, completely ignoring the fact that no physical injury occurred.
Yeah, but that intent is a tangible danger to society. The person who tries to poison a coffee pot with sugar today, well, they might grab the real arsenic tomorrow. The law has to address the risk they pose.
A danger? Perhaps, but punishing an entirely impossible outcome is the height of classical rigidity. It's punishing the attempt of a ghost. And even your prime example of grace, the favorable retroactivity in Article 22, where people got community service, has a built-in mechanical failsafe.
You mean for repeat offenders?
Exactly. The law explicitly denies that favorable retroactivity to habitual criminals. If you are a repeat offender, the law flatly refuses to look backward to help you. When pushed, the code always reverts to its baseline. It does not rehabilitate, it punishes.
But if we're talking about intent and this felonious spirit, let's dive into how the law practically calculates that intent versus the actual harm caused, because this doesn't exist in a vacuum.
Sure.
In criminal law, we talk about felonies committed by what we call dolo, which is deliberate deceit or malice. It requires freedom, intelligence, and a specific intent to commit the act. And then we have culpa, which is just fault or negligence.
Like causing a car crash because you weren't paying attention.
Right.
And how the RPC bridges the gap between that deliberate intent, the dolo, and the unintended consequences of an action is exactly where this 1932 steel skeleton shows its teeth.
How so?
Well, the doctrine of proximate cause under Article 4 dictates that you are criminally liable for all the direct, natural, and logical consequences of your felonious act, even if the resulting harm was completely unintended.
Which brings us to the concept of aberratio ictus?
Yes, a mistake in the blow. Let's look at a real tragic scenario. People versus Iligan. In this case, an individual launched an armed attack against a specific vehicle, intending to harm the people inside.
Right.
But in the chaos, the attack missed its intended target and accidentally killed a completely innocent bystander standing nearby. Now, if the RPC were a truly nuanced, positivist system that evaluates the mind and the specific intent of the offender, you would recognize that the specific dolo was completely absent.
The intent to kill that specific bystander.
Exactly. The intent to commit murder against that specific person just wasn't there.
I see why you think that, but let me give you a different perspective. The court applied full liability for the death in that case.
Yes, they did. Because under the RPC, the law ignores the specific volition required for murder. It opts for a mechanical equation where the offender is punished for the objective result, regardless of their actual intent toward the person who died.
But the law is not ignoring intent. It is enforcing rigorous, necessary accountability for the natural consequences of introducing malice into a peaceful society. Think of it like tipping a massive line of dominoes.
Okay.
If you consciously, willingly push that first block with malicious intent with dolo, you are responsible for the entire chain reaction. You don't get to say, well, I didn't perfectly anticipate how the last block would fall, so I shouldn't be blamed for it.
But the punishment should match the specific intent, not just the physical chain reaction. I mean, if I intend to break a window and accidentally cause a structural collapse, my mind only intended vandalism, not terrorism.
If we only punished perfect intent, we would leave society incredibly vulnerable to reckless violence. The causal link the courts look for isn't just a physical observation, it's a profound moral one.
A moral observation?
Yes. The legal maxim here is, he who is the cause of the cause is the cause of the evil caused. Take the case of De Ocampo v. Secretary of Justice. This is a perfect illustration.
Oh, right, the headbanging case.
Yeah, the accused aggressively banged two students' heads together. The victims were taken to the hospital, where they subsequently received incredibly unskillful, botched medical treatment, and they died.
And the defense obviously argued that the medical malpractice was an intervening cause. The doctors killed them, not the person who bumped their heads.
Exactly. But the court said no. Banging the heads together remained the proximate cause of death. The law isn't being rigidly mechanical here. It's laying down a moral boundary.
But the doctors literally made a fatal error.
Sure, but the court is saying that once you voluntarily abandon your moral agency to commit a violent felony, you do not get to wash your hands of the tragedy that directly unfolds from it just because the doctors made a mistake. You started the fire.
That is a beautifully poetic way of defending strict liability, but it absolutely proves my point. The classical theory focuses on the objective result of the act, the dead bodies, rather than the subjective intent of the criminal.
I don't think it's entirely objective.
By punishing the unintended result so severely, the RPC operates like a machine. It does not pause to ask if the offender needs psychiatric help or if the circumstances were uniquely chaotic. It just measures the blood spilled at the end of the domino chain and dispenses a proportionate penalty. It's an algorithm.
It is an algorithm that protects victims. And that actually bridges us perfectly into how the law measures the timeline of a crime.
Okay,
If you're arguing that the law is just a blind machine crushing people the moment they step out of line, how do you explain the nuance of Article 6? This article covers the stages of execution of a crime: attempted, frustrated, and consummated. It dictates exactly when an act becomes fully punishable.
I would argue that Article 6 is one of the most problematic areas of the code when it comes to human nuance.
I couldn't disagree more. The consummation point of a crime shifts depending entirely on the nature of the violation, which shows the law adapting to reality.
How so?
For example, in arson, the slightest burning of a building consummates the crime. You don't have to burn the whole house down, just charring the wood is enough. In theft, it's not just grabbing the item, it's the unlawful taking plus gaining final control over it.
Right, there are different thresholds.
But the most striking example of this modern adaptability is in the crime of rape. In the 1999 case of People v. Quinola, the Supreme Court established a vital legal fiction. The concept of frustrated rape simply does not exist in Philippine law.
Right, the court ruled it is inconceivable.
Yes. The slightest contact of the male organ with the labia is enough to completely consummate the crime. Anything short of that is merely attempted. There is no middle ground where the crime is frustrated or interrupted after penetration begins.
I know the ruling well.
This is not ancient rigidity. This is a profoundly modern, victim-centric protection of human integrity. The law adapts its definition of consummation to the specific, deeply traumatic nature of the violation. By eliminating the frustrated stage, the code ensures that the exact moment the violation of a person's physical boundaries begins, the justice system views the crime as complete.
Well, I come at it from a different way. You are framing the elimination of the frustrated stage as a modern, progressive victory for victims. And emotionally, I completely understand why that resonates.
But legally, you disagree.
Legally, mechanically, if we look at how Article 6 operates, this legal fiction is incredibly destructive to the concept of free will and rehabilitation.
Wait, how can protecting a victim's dignity be destructive?
Let me explain the mechanism of how a crime executes under the law. Legal scholars divide the execution of any crime into two distinct phases: the subjective phase and the objective phase.
Okay, tracking.
The subjective phase is the period from the very first overt act up until the offender has done everything they need to do to commit the crime. Crucially, during this subjective phase, the law leaves room for human conscience. The offender can spontaneously desist.
Meaning they can stop themselves before the damage is fully done.
Yes. Imagine a burglar who picks the lock of a house, steps inside, but suddenly feels a crushing wave of guilt. They turn around and walk away without taking anything. The law wants to reward that.
Right. It wants to encourage people to abandon their criminal designs.
Exactly. So it allows them to avoid liability for the consummated crime. Now, the objective phase begins the moment the offender has performed the last necessary act, the point of no return.
The bullet has left the gun.
Yes. If the crime fails hearsay, a victim survives a mortal gunshot wound because a highly skilled surgeon intervenes, it is a frustrated felony. The criminal did everything to kill them, but something outside their control stopped it.
Right, so applying that to Quinola, the injury to the victim's dignity happens immediately upon contact. There is no middle ground.
But look at the mechanism of what it does to the offender's legal standing. By making frustrated rape legally inconceivable, the law artificially collapses the subjective and objective phases.
I see.
It ensures maximum retributive punishment the millisecond an overt physical contact occurs. It leaves absolute zero legal room to recognize an offender's changing volition, a sudden crisis of conscience, or spontaneous desistance. It slams the door on conscience.
But you are applying a theoretical...
Once again, the RPC prioritizes mechanical retribution. It demands the maximum penalty instantly, entirely bypassing the positivist consideration that the human mind has the capacity to correct itself.
Okay, but you are applying a theoretical, academic framework of desistance to a crime where the trauma is instantaneous and irreversible. You can't unring the bell of that specific physical violation.
I'm not saying the trauma isn't real.
But the burglar returning the TV is not the same as a physical assault. The RPC isn't being rigidly classical here. It is recognizing the reality of the harm. The law is simply matching the objective reality of the crime.
It is matching it with a sledgehammer. And my issue is that this sledgehammer approach applies not just to individual acts, but to how the code handles collective human behavior. Let's expand this from individual tipping points to Article 8, conspiracy.
Ah, the famous doctrine. The act of one is the act of all.
Precisely. And this rule casts an astonishingly wide net that completely strips away individual nuance. When a conspiracy is proven, every single participant, from the mastermind who planned the murder to the guy who just stood by the door as a lookout, shares equal liability for the crime.
They participated in the design.
But my concern is how terrifyingly easy it is for courts to infer this collective guilt. Let's look at the 2024 case, People v. Brigais.
The implied conspiracy case.
Yes. In Brigais, we aren't talking about a mafia syndicate plotting in a smoky back room. We're talking about a chaotic assault. The court inferred an implied conspiracy simply from joint physical acts during a fight. There was no proof of a formal agreement.
Just people acting in concert in the heat of the moment?
Right. This doctrine allows courts to infer collective guilt mechanically. It completely bypasses the strict requirement to prove individual dolo, that specific malice and intelligence, for every single participant's distinct actions.
So you're saying it assumes everyone wanted the exact same outcome?
And suddenly one of them unexpectedly pulls a knife and stabs someone. Implied conspiracy means the punchers are suddenly on the hook for murder. It is the ultimate expression of classical retribution, collective punishment for a collective outcome, regardless of individual psychological intent.
That is a very selective reading of modern conspiracy jurisprudence. You are focusing on the net, but you are ignoring the incredibly stringent protections the Supreme Court has actively built into this rule to prevent exactly the kind of overreach you are describing.
But the Brigais ruling shows how easily the net is thrown.
Then you have to look at the 2025 ruling in Ampatatan v. People. That case explicitly clarified the boundaries of conspiracy and reined it in. The court ruled that mere presence at a meeting, or even silent approval of a corrupt plan, is wholly insufficient to establish conspiracy.
But if they take physical action,
yes, the law demands a physical, overt act in actual furtherance of the crime. This is a vital protection for the individual. It ensures that you are not punished merely for association or for just being in the wrong place at the wrong time.
sure, but
If you do not commit an overt act that actively contributes to the shared criminal design, you are not a conspirator. This actually protects the classical demand for absolute free will. The state must prove that you freely and intelligently chose to physically advance the specific crime.
Okay, but let's follow the mechanism to its conclusion. Once that minimal overt act is established, say you were just a lookout standing outside the bank, the liability skyrockets completely out of proportion to your specific action.
The liability is shared.
But you receive the exact same afflictive penalty, perhaps reclusion perpetua, life imprisonment, as the person who actually walked inside and pulled the trigger. Where is the positivist nuance there? Where is the individualized assessment of the offender's specific clinical state, their background, their minimal involvement? It vanishes the moment the conspiracy is triggered.
It doesn't vanish, it shifts. It shifts to the penalty phase and the judge's appreciation of mitigating circumstances. A judge can look at the lookout and apply different mitigating factors than they would for the shooter.
But the baseline liability,
But the foundational liability, the fact that a crime was committed collectively, must remain firm. Otherwise, organized crime would simply compartmentalize their actions to escape justice. The RPC's architecture provides the scaffolding, and the judges provide the nuance.
But the scaffolding itself forces the judge's hands. You cannot build a rehabilitative, positivist justice system on a foundation that punishes impossible crimes where no one is hurt, enforces absolute proximate cause regardless of actual intent, and equates the kid keeping watch at the door with the mastermind pulling the trigger.
Let's bring this to our conclusion and summarize exactly where we stand on this architecture. I maintain that while the RPC's foundation was undoubtedly classical when it was enacted in 1932, it has been successfully transformed. We see this deeply embedded through interpretive filters that the courts apply daily, like the equipoise rule.
Madayada versus people.
Exactly. In plain terms, the equipoise rule mandates that if evidence in a criminal trial is evenly balanced, if it's susceptible to two interpretations, one leading to guilt and the other to acquittal, the court is legally bound to favor the interpretation leading to acquittal. Tie goes to the runner.
I'll grant you that rule is important.
That is not the rule of a rigid, retributive machine looking for blood. When you combine the equipoise rule, the rule of lenity, the retroactive application of laws like the Community Service Act, and modern rulings admitting psychiatric episodes to negate intent, you see a highly dynamic, adaptable system. It is a system that respects human frailty while maintaining the necessary order for society to function.
And I maintain that you are confusing the furnishings for the foundation. The positivist psychiatric admissions and the retroactive community service exceptions are merely modern wallpaper glued over a steel structure designed to mechanically punish the act.
Even with all the Supreme Court interventions?
Yes, because when we look at the core, unyielding mechanisms, the punishment of the felonious spirit in impossible crimes, the strict liability of aberratio ictus, where a mistake in the blow still yields a murder charge, and the inescapable net of implied conspiracy, the Revised Penal Code remains stubbornly classical. It is a retributive engine that prioritizes the objective result over the subjective human condition.
It is a tension, undeniably, and honestly, perhaps it is that enduring tension between the 1930s text and modern Supreme Court decisions that makes the Philippine justice system so endlessly fascinating.
I will definitely agree with you there. The struggle between the desire for strict retribution and the hope for human rehabilitation is written into every major decision coming out of the Supreme Court in Padre Farah.
It forces all of us to constantly ask the hard questions. How should a legal code balance strict accountability for the harm caused with a compassionate understanding of the mind that caused it?
It is an incredibly delicate balance, and there is certainly much more to explore and the nuances of how Philippine jurisprudence attempts to strike it.
Indeed. So, we leave it to you to decide. When you look at the Philippine criminal justice system, do you see a modern structure adapting to the complexities of the human condition, or do you see the ancient, unbending steel of 1932? Thank you for joining us on the debate.
We will now summarize and conclude our discussions in this video, which provides a visual blueprint of Articles 1 through 10 of the Philippine Revised Penal Code. We have examined the foundational system of classical retribution while noting modern updates influenced by positivist jurisprudence. We explore the philosophical tug-of-war between classical and positivist theories. While classical theory emphasizes free will and retributive justice, the positivist perspective views crime as a social phenomenon, focusing on rehabilitation and specialized measures. The jurisdictional reach of the law is defined by three pillars: generality, which binds everyone in the country; territoriality, covering borders and seas; and prospectivity, ensuring laws move only forward, not backward. Sovereignty on the seas follows the English rule. Internal affairs of a foreign merchant vessel are generally outside local jurisdiction, unless a crime disturbs the security of the port or the host state. Article 22 introduces the favorable exception. New laws apply retroactively if they benefit the accused. However, this does not apply to habitual criminals, reinforcing the code's retributive core. Understanding liability requires distinguishing between dolo, which involves malice or deceit, culpa, which covers negligence, and mala prohibita, where statutes strictly prohibit acts regardless of intent. Mental health is evaluated beyond the presumption of sanity. The law accounts for diminished willpower and full insanity, with recent jurisprudence allowing psychotic episodes to be relevant even without prior records. Proximate cause determines liability. If an act is the direct and logical consequence of the crime, the offender is responsible. This applies even in cases of mistaken identity or unintended results. The impossible crime paradox addresses scenarios where a crime fails due to inherent impossibility or ineffective means. The law focuses on the felonious spirit of the actor to deter criminal intent. Execution is split into two phases: the subjective phase, where an offender may still desist, and the objective phase, where spontaneous desistance is no longer a defense once the act is underway. Consummation varies by crime. Theft requires final control, arson starts with slight burning, and rape is viewed as complete upon the slightest contact to protect the victim's integrity. Conspiracy triggers collective responsibility under the Act of One rule. An act of conspiracy requires an overt act in furtherance of a shared design, rather than mere presence or approval. Interpretative safeguards include the equipoise rule for evidence, the rule of lenity favoring the offender in statutory interpretation, and the primacy of the original Spanish text of the 1932 Code. In synthesis, the first 10 articles of the Code form the DNA of Philippine justice. While built on 1932 foundations, the system remains a living, breathing framework, continuously shaped by modern judicial interpretation.